welcome back or welcome to the afternoon session of the regular meeting of the Board of Lane County Commissioners. Today is Tuesday, October 8th, 2024. Welcome to those of you joining us in person here in Harris Hall or to anyone watching online. We will jump right into Public Works, item 10A, and shift from my agenda to my script. This is an on-the-record hearing in the matter of review of the hearing official's decision to deny 3 forest template dwelling proposals in the impacted forest lands zone, or F2, on individual properties adjacent to the Oak Ridge Airport, specifically Assessor's Map 21-25-12, Assessor's Map 21-35-07-03, and Assessor's Map 21-35-07-30. I did not read out the file numbers or tax lots. I'm assuming that's fine, or do you want those read into the record?
I would recommend reading into the tax lot. You do not have to read in the file number.
Thank you. So Assessor's Map 21.25-12, tax lot 843. Assessor's Map 21-35-07-30, tax lot 2900. And Assessor's Map 21-35-07-30, tax lot 2800. This hearing is continued from April 16, 2024. Today's date is October 8, 2024, and it is 1:34 p.m. On April 16th, 2024, the board passed a motion to continue the public hearing on this matter to a date and time to be determined. Notice the hearing to allow parties as defined by Lane Code Chapter 14 to participate by presenting oral argument limited to the hearing's official record and limited to Policy 11 and its interpretation. Policy 11 is the Lane County Rural Comprehensive Plan Goal 5, Flora and Fauna, Policy 11. The parameters and procedures for the hearing are as followed. Again, this is a continued on-the-record hearing with limited additional testimony allowed. In accordance with the board's approved motion for this hearing and Lane Code Chapter 14, the scope of this continued on-the-record hearing is limited as follows. The only persons that may participate in this hearing are the planning director, the planning director's designated representative, the applicant, the applicant's representative, and persons that appeared to the hearing's official, either through written or oral testimony made on or prior to the hearing's official's initial hearing of December 7, 2023, and any representatives of such persons. And I will note staff has a list of names, so as people wish to testify today, we will be checking against that list to ensure you are eligible to present today. Parties may present oral testimony restating arguments and evidence that's contained in the hearing's official record as it relates to Policy 11 and its interpretation. Each person presenting oral testimony will be limited to 5 minutes. The only testimony allowed is oral testimony made during this hearing. No written testimony will be accepted. The subject matter of this hearing is Policy 11 and its interpretation. Oh, this is a repeat, excuse me. No new arguments will be accepted. Lane Code Chapter 14 defines argument as assertions or analyses regarding the satisfaction or violation of legal standards or policy believed relevant by a party to a decision. Argument does not include facts. No new evidence will be accepted. Lane Code Chapter 14 defines evidence as facts, documents, data, or other information offered to demonstrate compliance or noncompliance with the standards believed by the proponent to be relevant to the decision. Commissioners will be asked to disclose any potential or actual conflicts of interest, ex parte contacts, personal knowledge, bias, or prejudgment on the matter before us. Everyone in attendance, virtually or in person, will be provided an opportunity to challenge commissioners' disclosures and ability to participate in this review of the hearing's official's decisions, but no testimony, evidence, or argument on the merits of the applications will be considered through the opportunity to challenge. Failure to raise an issue accompanied by statements or evidence sufficient to afford a commissioner with the opportunity to respond may preclude appeal of this issue to LUBA, the Land Use Board of Appeals. The order of the proceedings will begin with a staff report. The applicant and applicant's representatives may then present, followed by parties that participated in the hearing's official proceedings based on the limitations described earlier. Parties in favor of the proposed template dwelling applications will be called first, followed by parties neither in favor nor opposed. And then parties opposed to the template dwelling will be allowed to present. The board will then allow any additional statement from the planning director and final response from the applicant and their representatives. After each presentation, the commissioners will have an opportunity to ask questions before moving to deliberation and any decision. The board's decision will be the final local decision, appealable to the Land Use Board of Appeals. And with that, I will welcome Shauna Adams to provide the applicable criteria.
Thank you, Chair. The criteria applicable to this request are the forced template dwelling provisions referenced in Lane Code Section 16-11, subsection 2-2.4, House Bill 2225, and Rural Comprehensive Plan Goal 5, Flora of Fauna Policy 11 to the extent applicable.
Thank you. At this time, I'm going to call on commissioners to make any disclosures. We will start with any disclosures of conflicts of interest. All commissioners are required to disclose any potential or actual conflicts of interest that they have with the matter before us. Such disclosure must describe the nature of the conflict. If a commissioner or one of their relatives or any business with, if a commissioner or one of their relatives or any business with which either is associated could be financially impacted positively or negatively by the proposal, that must be disclosed for the record, followed by a statement that the commissioner can or cannot proceed. If a commissioner has an actual conflict of interest, the commissioner must recuse themselves. I will go one by one with the commissioners to ask if there is a need to disclose either a potential or actual conflict of interest. And I will start with Commissioner Senega.
None.
Commissioner Buck.
None.
Commissioner Farr.
Ed King was on the board of directors of Food for Lane County when that board of directors hired me in 2003. That job paid about $60,000 a year, but I have that is a potential, but I don't perceive it as an actual conflict of interest.
Vice Chair Lovall.
Ed King donated to my campaign. Other than that, I have nothing other to disclose.
And Chair Lori Trieger, I have no actual or potential conflict of interest to disclose. And now for disclosure of any ex parte contacts. Because this is a quasi-judicial matter, commissioners must disclose any ex parte contacts they have had. An ex parte communication occurs when a board member in a quasi-judicial proceeding communicates, directly or indirectly, with any person or party in connection with a matter before the board, absent of notice and opportunity for all parties to participate. Commissioners must disclose any ex parte communication. If any commissioner has received ex parte communication, then please, for the record, disclose the substance of any written or oral ex parte communications concerning the decision before us, and 2, state whether you can render a fair and impartial decision based on the facts and the law. And we do have outside counsel from Miller Nash offering a little extra support to us today online. Counsel Tran Cafe, are you with us online? There you are.
Yes, hi.
Do you have any additional guidance for the board on disclosing any ex parte communication? Nope. You're frozen from our end. We'll give it just a minute. I will note for the record, out of an abundance of caution while we're paused, going back to conflicts of interest. I didn't disclose because I don't believe it is, but since Vice Chair disclosed contributions to campaign, I also received in 2020, but not in the most recent cycle, contributions from Ed King to my campaign. Council, are you able to hear us?
Chair, if I may, her connection failed, and she's trying to reconnect.
To log back in? Great, thank you.
I'm so sorry. I think I'm back, but I'm going to keep my video off.
Yep, we have good audio on you. Thank you.
Okay. So I lost my connection right as you introduced my name.
Thank you. Yes, we were just asking if you had any additional guidance around disclosure of ex parte contacts for commissioners before we move forward.
Sure. I think the important thing about this type of disclosure is to make sure that there's enough description of the substance to allow any party that wishes to rebut the substance of that ex parte contact to be able to do so. And when considering what constitutes an ex parte contact, it is communications outside of the formal hearing process that are related to the subject of the hearing. I think there were specific questions about whether all of the names of constituents who may have emailed commissioners need to be disclosed. And the answer to that is no, as long as the substance is described. I know the commissioners probably receive mountains and mountains of emails. And then there is an issue about information that may not relate specifically to these applications, but may impact the decision. For example, communications with a land use attorney about F2 land use issues that were not made in the context of this proceeding. That would not be an ex parte communication, but it could be considered personal knowledge, and there will be disclosures about personal knowledge later on. So when thinking about whether the disclosure falls more properly under the ex parte communication portion of these disclosures or the personal knowledge portion, keep that in mind. The disclosure itself is basically the same. You must disclose the substance of the personal knowledge or the substance of the ex parte contact.
Thank you. I think so. I think I understand. So procedurally, we would do each of those separately, I see here. Okay, so one, we'll do a round on ex parte and then a round on disclosure of personal knowledge, bias, or prejudgment, and you're suggesting that is that second category is an area different, more broadly to a topic?
Correct.
Thank you.
Yeah, if it is personal knowledge that will be used by the commissioner in making this decision.
Thank you. Is that clear to the board?
Nope.
No. Commissioner Farr says no. Everybody else says yes. Do you have a question for council?
Well, we received testimony as early as this morning, as late as this morning, about F2 land. So I hear on a regular basis about F2 land, and I don't know if that has anything to do with well, maybe my internal knowledge of F2 land and the people's general feelings about F2 land. We received testimony this morning. We all heard it.
So
Not about this particular case, but it sounds like just a generality of knowledge of F2 land or having some form of opinion on how to use F2 land.
I think if there are sort of borderline questions, then my advice would be to err on the side of disclosure. So if you're not quite sure whether it falls into one of the categories, I would advise to make the disclosure and describe the substance of the communication.
Thank you. So first is, I think what is more clear and understood, more accustomed to, is disclosures around ex parte communication. So I will go one by one again and ask if any commissioner wants to disclose needs to disclose any ex parte communication, starting with Commissioner Senega.
I have none.
Commissioner Buck.
I will just disclose that I've received a lot of emails and inquiries from residents in the area concerning the impacts to the community of the TB Butte quarry application. I don't think that will affect my qualifications for hearing this particular matter. but I wanted to make sure to disclose that to the public.
Thank you. Commissioner Farr?
With the caveat that Commissioner Buck just entered, I have none.
Vice Chair?
I have disclosed in the April 16th meeting a list of email people, unquote, that I said in that meeting consistently and specifically adheres to the concerns of Paul Westfalt in Jasper, who had an F2 property, who approached me before I was a commissioner while campaigning, and Daniel Basaraba, a friend of mine, which had some issues in the Crestwell area. He shared with me his plight, and also the recent case that we've heard, the Perkinses before the board, and today's public testimony on F2 lands.
And I have no ex parte communication to disclose. And so now I'll ask commissioners to disclose any personal knowledge, bias, or prejudgment related to the matter before us. If a commissioner uses personal knowledge acquired outside of the hearing process in rendering a decision, the commissioner must state the substance of the knowledge on the record. Does any commissioner need to disclose personal knowledge, bias, or prejudgment? Commissioner Senega.
I have no bias, but I have received lots of emails about F2 land from, I don't know if they're owners or consultants, but yes, lots of questions and concerns on F2 lands.
Commissioner Buck?
None.
Commissioner Farr?
I have none, with the same caveat that Commissioner Senega just entered.
Vice Chair?
I have received many, many emails on that. In specific, I want to say my personal knowledge, I've sought explanations of Policy 11 and Goal 5 from Council Bill Cluse, my neighbor land consultant Jim McLaughlin, and Council Mike Reeder for better understanding of the policy's history and past board proceedings which are on our record. The board has also had staff training on 2 separate occasions pertaining to land use, zoning, and specific questions from me regarding F2 land and its policies. And we've also had a handful of attorney-client emails that were confidential that were sent to all of the board. I was included. I have not, under any circumstances, or had any conversations or any communication from the applicant on the aforementioned or the matters at hand today.
Thank you. And for myself, in the personal knowledge, I declare no bias or prejudgment, but on the personal knowledge, I have sought out just information to ground myself in these matters since taking office in 2021 from staff with land management and legal counsel internal to Lane County. Regarding communications with outside parties, constituents, my practice is to send a template email back acknowledging receipt and letting the person who sent it know that I can't have any discussion about land use matters outside of public hearings and directing them to the appropriate staff. So that is the extent of any of my prior to or outside of public hearing communications on these matters. At this time, if there is anyone in attendance, either virtually or in person, so Tanya, I'll ask in the room first and then ask you to check with online participants. At this time, anyone may rebut the substance of any of the ex parte contact that has been disclosed and challenge the qualification of any commissioner based on conflict of interest, ex parte contact, personal knowledge, bias, or prejudgment. Is there anyone present in Harris Hall who would like to rebut what they have heard or challenge the qualifications of a commissioner's ability to participate in this review of the hearing's officials' decisions? Sir, would you please step to the podium? Please state your name for the record and whether, and explain your challenge, the basis for your challenge, and then we'll give the commissioners an opportunity to respond.
Thank you. Sean Malone on behalf of Landwatch Lane County. The one thing I'm not going to address is conflict of interest, but I will begin with ex parte contacts. Commissioner Senega, you said you received, and we'll just do Commissioner Senega and Commissioner Farr. You both said you received numerous emails, I don't know, had conversations, whatever, about F2 lands. Now, obviously, we're here about something more specific than just F2 lands. We're here about the interpretation of Goal 5 Policy 11. Have you received communications, emails, or personal communications about the interpretation of Policy 11 under Goal 5?
About the interpretation, no.
Okay.
In the last 11 years, almost certainly.
Excuse me, just a
If
minute.
I can interrupt for a
Thank you,
procedural matter, I recommend that the commissioners respond at the end of all of disclosures, but it's at your discretion on how you would like the proceeding to
Thank you.
go.
So, Mr. Malone, do you have other points that you would like commissioners to respond to?
Yeah, I have many points.
So perhaps if you could go through them, and then I'll offer commissioners an opportunity to respond point by point.
Okay, my only suggestion would be not to go through all of these things, conflicts of interest, bias, prejudgment, personal knowledge. It might be easier just to do ex parte first and then go on to the
And then
next
have
one.
response per
Yeah,
council,
maybe
is
that would be,
You can do that. That's a deviation from the script, but I think it's an efficient way to be able to, for commissioners to respond.
So you're presenting challenge based on ex parte contact at this time.
at this time.
Do you have any other around ex parte than what you've stated already?
Yes.
Right?
So Mr. Cluse and Mr. Reeder have never contacted you about the policy, policy 11 and the interpretation of it in Goal 5.
I didn't say that. I said that over the last 11 years, I've talked to a lot of people about Policy 11, Goal 5, because it's a common item of discussion in this Board of County Commissioners. Go through the record. It happens all the time, of course. Of course it does.
Is that the extent of your disclosure?
I don't know what more you need. You know, I trust my attorney.
If you could place the content, the specific emails or whatever you have about those
Going
those
back 11
discussions.
years, going back 11 years?
Maybe we should just start with the Nimkish decision and the King decision, because anything prior to that is sort of irrelevant, isn't it? I don't even think, it's probably unlikely that you received any sort of interpretation or communications about Policy 11 prior to this.
Mr. Malone, I would ask you maybe to ask a specific question that commissioners can respond to. Yeah, if you could just ask a specific question that a commissioner could respond to see if they can satisfy your inquiry.
Sure, I mean, he's talking about something 11 years ago, but prior to the Nimkish decision in about 2020 or 2021, this was never an issue. So anything before that has nothing to do with what we're talking about. I highly doubt anyone, was talking about this before the Nimkish decision. And so my specific question is, have you received communications from the applicant's attorney, Bill Close, or the applicant's not attorney, Mike Reeder, about the interpretation of Policy 11 under Goal 5 after the Nimkish decision, as well as the King decision? And if so, please place the substance of those communications, not just generalized, in the record. And I think the best way to do that would be to place those emails or other types of communications you may have in the record. So I can know what they're about. I can know what was said.
I have difficulty answering that question. There's nothing that comes to mind, so I can dig down into my emails and see what I can find, or you can, or anybody can, the public record.
It's your obligation, not mine.
Okay, I've told you what I'm telling you.
Okay, I find that to be inadequate, and so I'm placing that on the record. Same question.
No,
Senator.
I
Commissioner
haven't
Senator.
received any emails with interpretation from Bill Cluse or Mike Reeder.
Anyone else?
No, not interpretation of Goal 5, Policy 11, no.
Has anyone come to you about not being prohibited from building a forest template dwelling on F2 land related to the Nimkish and King decisions from the Court of Appeals and the Land Use Board of Appeals?
I don't believe Nimkish was brought up this morning, but you heard two of them this morning, so yes, it happens.
I did not hear that, so I wasn't here this morning. Can you place the substance of that on the record?
Let me go back through my notes.
I only ask because the disclosures have to be
It
adequate.
was Jim Belknap and Mike Evans, I believe.
What was the substance? So you just disclosed that they said something and you had ex parte contact.
You asked me what, and then you don't remember what you asked me?
There's two parts to this, sir. First one is disclosure. Second one is substance. What was the substance?
F2.
F2. So the zone F2, not anything more specific?
Being able to build on F2.
Okay. I find that inadequate. We'll move on to Commissioner Lovell. You indicated that you had lots of emails about F2 lands, and then subsequently, you didn't disclose for ex parte contacts that you had talked with Mr. Close and Mr. Reeder. Are you willing to disclose with regard to ex parte contacts that you had communications with them?
Council Malone, that was under personal knowledge. That was not ex parte contact. My disclosure of ex parte contact is the substance of the April 16th meeting, and subsequently my email list submitted to the county council.
Has that been made available, the email list? Has it? I don't know.
I answered an email saying I give my list of emails that I've had, and that's what I supplied.
Council?
I'm unaware of that. I can check my email. I am unaware of that communication.
Maybe it wasn't done. I don't know.
Personal knowledge is the ones that I stated, the information of seeking policy knowledge and Goal 5 information. That was on personal knowledge. It wasn't on ex parte contact.
So you got personal knowledge from Mr. Close and Mr. Reeder, but you don't have ex parte contacts with them?
Ex parte contact would mean they would mention the applicant at hand in a specific case, so no. It was general knowledge about what Policy 11 and Goal 5s was that the board had in past on the record, and my own research of the videos that the county has posted.
So the Miller Nash attorney just said it's about the substance of the hearing, not necessarily, the substance of this hearing is about the interpretation of Policy 11, Goal 5. You had communications with Bill Close and Mr. Reeder, correct?
Are you wanting me to repeat my same answer more than once, Council Malone, or is this just badgering I'm experiencing?
I'm trying to help you out.
Okay, I'm trying to help you out too. Why don't you turn your ears on for a minute and listen to what I'm going to say, sir? How about I say, I've sought explanations of Policy 11, Goal 5, under personal knowledge, from Council Bill Cluse, my neighbor land consultant Jim McLaughlin, and Council Mike Reeder for better understanding of the policy's history and past board proceedings, which are on record. That's what I said.
Okay, so you have no ex parte contacts with Bill Close and Mike Reeder?
No.
That's your position?
No, personal knowledge. That's what I stated.
That's an ex parte contact, but if you're going to say you don't have one, I mean, so you have to make these disclosures under both things, I think, here.
No, I don't.
If we could not have comments from other commissioners that aren't speaking, that would be great. I appreciate that.
Okay,
So I guess-
you, sir, had said on the meeting prior when it started that you wanted to break this up into categories. Your specific category is ex parte. That's what we're talking about now. I'm saying that I've disclosed that already, and that under personal knowledge, if you want to go to the next
I'm
category,
not
then
there
I've said
yet.
that.
I'm not there yet. I have more questions for
Okay.
you on ex parte
Okay.
contacts. So you have ex parte contacts with Bill Close and Mike Reeder, correct?
No,
You don't?
I have personal knowledge contact with those people.
Okay. I feel that your disclosure is not only inadequate, but you're not providing the substance of those communications that you're admitting to having. So I guess we'll just move on then to further ex parte contact.
Chair, if I may?
Yes, please,
If
Council.
you'd like to have Council Tran Cafe reiterate what the parameters are for disclosure of ex parte communication, that may help the commissioners as well as parties that are rebutting.
Thank you for that. I was just bringing up a memo we had from council back in the spring when this issue was before us, but if we could have real-time input. Council, are you able to hear us?
Yeah, can
So
you
I
hear
think
me?
what we're looking for is some clarification and definitions around ex
Yes.
parte contact versus personal knowledge, bias, et cetera. Thank you.
Sure. So ex parte contact is communication with a decision maker made outside the hearings process regarding a matter relevant to the decision. And then personal knowledge is personal knowledge acquired outside of the hearing process in rendering a decision. And so the distinction, which I don't want to get too caught up in, is whether the communication is specifically about these applications, or if it's more general matter that will nonetheless influence the commissioner's decision on the application. But I think what I see as maybe the sticking point is both disclosures require disclosure of the substance of either the ex parte communication or the personal knowledge. And so I think the speaker whose name I failed to write down is feeling like the substance hasn't quite been disclosed in a way that allows him to rebut that substance.
Thank you, Counsel. Mr. Malone is the counsel at the podium right now, and does that fit with what you're after, sir? Are you looking for substance more than whether it's in the category of personal knowledge or ex parte? Is that what's missing for you, that we could maybe keep things moving by asking for that to be disclosed?
Thank you for the question. First part about ex parte contacts, and that's really the only thing I'm addressing here at this point, is disclosure, and then the substance of those. I feel like all three of the commissioners that have questioned have not provided any of the substance. I feel like that could be done very easily by providing the emails, but if the commissioners would like to otherwise provide the substance of those conversations, I welcome them to do so, and I find their disclosures of the substance inadequate at this point in time. Hearing nothing, I will move on.
Well, let me give just a moment. Is there any commissioner that wishes to offer anything more in regards to the substance of the communication, setting aside for a moment whether it's considered prior knowledge versus ex parte? Commissioner Farr.
Well, I just brought up all my emails from Bill Close. I've not deleted any emails. And if you want to hear all of these, it'll take us all day. Because going back to 9/18/23, Bill Close testimony on
You can also just
erosion
put them in the
control.
record.
Please
Say
don't
that again?
interrupt the commissioners, Mr. Malone. Thank you.
There's a long list here, but all of them were sent to all board members. So do we all have to give you this list as well? Does everybody have to give you the list because we all got the same message?
If you're telling me that the emails that,
I can't talk
Yeah.
about anybody else's emails. I can talk about mine right here.
well, you said that they were sent to everybody.
Well, there's an address block on an email, it says to. Okay.
Mr. Lovell, or Commissioner Lovell, were you sent, the emails that you were sent from Mr. Close and Mr. Reeder, were they sent to the email address that Commissioner Farr is referring to?
I can't speak specifically to all of them, but most of them, yes.
So not all of them. Are you willing to provide the substance of those emails that weren't sent to everyone?
I've got them all right here. How many do you want to hear?
If you just place them in the record, I'm happy with that. That'll probably be your
In fact,
safest.
there's even one from you, Mr. Malone.
I don't send specific emails just to you, sir. I've never done that.
Well, funny how I got it. It was addressed to the Lane County Board of Commissioners.
Again, I have never sent you specifically an email.
Okay, well, I've got approximately 30, maybe 35 emails here that I was asked to print out in this case, and the substance of them are just informational. There's a couple of them that are about TV Butte, about toxic chemicals in F2. There's a couple of them about certain historical proceedings, for example, the Terre Haute presumptions. There's information that would help me get better eyes on what I'm about to think about as a county commissioner, F2 lands and land use. There's one off Planktown Holdings, as I'd mentioned before, that was Daniel Bossaroba. There is a history of King's applications, how they were filed in the county and what under they were filed. There was a couple of misstatements and bad assumptions. Someone had wrote to me that you had spoken at a public meeting. And there was one about the land use law is complex and often obtuse, of which someone rebutted that your job is to find out what that means. So these are basically the substance of that, educational for my own purpose and to find out what I need to know about Policy 11 and Goal 5 to make an educated decision in this board.
So toxic chemicals, Safe TV Butte, although I'll make a note of that, none of those have to do with this case. So again, I'm going back to the substance of the issues regarding this case. That's what I'm looking for.
Okay.
Not irrelevant stuff.
That's what I got for you, sir.
Okay, at the June 16th, 2023 hearing, you indicated that, you stated, I quote, "I have a lot of questions from some of the constituents that have been emailing me about this." Who were those? Can you place the substance of those before
I have placed the substance of Daniel Bassaroba and the other party that I aforementioned, Paul Westfall, who since moved out of the area because he couldn't sell his F2 property. So, but just in public meetings, private meetings, private speaking engagements, people have approached me and asked me about public land. So it's a topic of, I would bet, 2 or 3 times a week that comes up. So to put that into context or to give itemizations, that would be an onerous task, sir.
But the only names you have off the top of your head,
Those are the only ones that have email trails, sir.
Basaraba and Westfall.
Yes, sir.
Also, at the June 16th, 2023 hearing, you stated, according to them, from what I've heard, they were not part of the process. And that refers to this notion that folks were not part of the Nimkish and King decision. Is that just include the same people?
I'm not sure you interpreted my definition of process. You assumed that was from the case, and it wasn't. It was about the process of land management, and in my mind, as an entrepreneur, is and are people having property, are they having their rights violated and values stripped to them by the county? That's due process. That's a constitutional right, sir, which I'm sure you're familiar with. So that was my meaning of process, not your meaning of my meaning of process.
Further stated, I've had a couple of people that had wanted to sell their properties and came to the point of selling where they can't because of certain overlays of wildlife, and more specifically, it was elk wildlife. Is that the same 2 people, Westfall and Basaraba?
Yes, sir.
You further stated that some of the complaints that I have been hearing, constituents that have contacted me, is that they have lost a large degree of relative value because what they thought of as a buildable parcel of land is no longer.
Fact.
That's again Basaraba and Westfall?
Yes, sir.
Okay.
Excuse me, just one moment, Mr. Malone. Council, I'm getting some communications that you're having communications with outside council. Did you want to provide some guidance on process for a moment?
Yes, I'd like Council Tran Cafe to provide some guidance for the rest of the proceeding related to the disclosures and what we recommend that the board do to address some of the concerns.
Thank you.
Thank you.
Hi, Cosette Tran Cafe again. I think given the scope of, and
We seem to have lost you. I don't know if you can hear us.
If you could bear with us, I think it's important.
Yep.
Thank you.
Would you message?
sorry, I
There we go.
lost my connection again, but
Okay.
I'm back.
Thank you.
So my suggestion is if the board wishes to put the emails into the record, allow the parties the opportunity to rebut the substance in writing, and that way we can proceed with the rest of the hearing while still giving the parties adequate opportunity to make their challenges.
And can you advise commissioners specifically and explicitly the mechanism through which they, quote, put these items into the record?
Sure, we can make we can prepare a motion to continue the hearing, to keep the record open for the limited purpose of making those disclosures by including the emails and then allowing the written rebuttal.
Chair, may I ask a
And I'm-
clarification question?
Yeah, just one moment. And I'm not sure we've heard, I might want to make sure Mr. Malone has the opportunity to express all of the items which he would like disclosures to be produced, relating to which he would like disclosures to be produced. So if you can work with our council over this next little bit of time to draft something that is inclusive in that way, that would be helpful. And Commissioner Farr has a question. It looks like maybe, Shauna, did you have something you wanted to say or no? Okay, Commissioner Farr.
Once again, Chair, and once again, I am looking at a lot of emails from Bill Cluess. Bill is an attorney, and I'm sorry to say I don't read every word of every email that he sends to me, so I would have to send you every single email that he sent to me in order for you to determine whether or not that met your substance criterion. So, and there's a lot. I'll send them.
So, Mr. Malone, do you have maybe an overarching sort of request for the nature of the kinds of communications that you would like to see produced?
Yes, I mean, the emails themselves should be produced, in my opinion. Obviously, the substance of those is only required to be disclosed. I think the safest thing for the commissioners is to submit the actual emails. That's what I was referring to Mr. Lovell, or Commissioner Lovell. And, you know, that I think the suggestion of the Miller Nash attorney, Ms. Tran Coffey, I believe her name was, I think that makes sense. That's what I was suggesting earlier. So I have one more ex parte one, and then I'll be done with ex parte. Commissioner Lovell said, I'm thinking of those people that are on my communication list, what I'm going to tell them. So again, that's in the context of the hearing in which these applications were called up. And so that is the substance of what's going on here. I assume Basaraba and Westfall were on those. And, you know, if there are additional ones, or if Mr. Love or Commissioner Lovell has indicated that he has submitted that, but there seems to be some confusion about that, that communication list, as well as the communications themselves, should be introduced into the record.
It's not an extensive list, Mr. Malone. It's basically 2 people, and then obviously any other officials or any other people in a public setting that I've been to speaking that have mentioned the fact that they've had a hard time dealing with the F2 lands cases. It's just off-the-cuff people like that, but that's a considerable list of people.
I agree, 2 people is not a long list. Okay, next I have bias / prejudgment, and then I have personal knowledge. And I don't know, something, should I just go into those, or?
Sure.
Okay. Let's see here. Stick to the ones I didn't cover in the prior hearing. Commissioner Senega, you indicated at the June 16th, 2023 hearing, you stated, in the context of calling up these applications and the interpretations of Nimkish and King, that we need housing, housing, housing. I would hate to be more restrictive. How often do you say that before deciding on a matter that you would hate to do it one way or the other? Because I've never seen a judge do that.
That's just a statement that we have made as on this commissioner board, that we would like to follow state regulations. You know, we heard from Deflection today and HNHS today. We need housing in Oregon. I mean, it's a fact.
But this is in the context of these applications that you called up and you said, I would hate to be more restrictive. That's not an indication of how you were gonna rule?
I mentioned Nimkish when I said that?
This was in the context, June 16th, 2023, of you calling up these applications. You were well aware of the Nimkish decision at that point in time because it was presented to you in the home builder's letter. And you said, I would hate to be more restrictive. Again, I have never seen an impartial decision maker prior to making a decision say they would hate to rule one way or the other.
I wasn't saying I was ruling. I was saying I would hate for Lane County to be more restrictive.
Do you do things you hate?
Yes.
Enough said. That's all I have for Commissioner Senega with regard to bias and prejudgment. As it relates to Commissioner Lovell. At the June 16th, 2023 hearing, you said, I can't imagine how an over 80 acre or 40 acre or even a 5 acre parcel, how the footprint of a house is going to prohibit a herd of elk from coming through my property. This is essentially testimony in opposition to Policy 11 as currently interpreted. Because Commissioner Lovell is testifying against the policy, he has demonstrated bias, and I request that Commissioner Lovell recuse himself.
No, I won't recuse myself.
Thank you. I forgot to ask that last part to you, Commissioner Senega. Will you recuse yourself based on what I perceive to be bias?
No.
Back to Commissioner Lovell. You stated that we talk about the wildlife game habitat overlay and over we hear about elk habitat. It's interesting that elk habitat We're not talking about a real huge endangered species. It's elk, right? Not like African rhinos or wildebeest. Commissioner Lovall is testifying as to his opinion of the low importance of elk habitat. And Goal 5 and Policy 11. Again, this is essentially testimony in opposition to Policy 11 as currently interpreted. Because Commissioner Lovall is testifying against the policy and the current interpretation, he has demonstrated bias. Commissioner Lovall must recuse himself for bias. Will you do so?
No, sir, I won't. Are you familiar with the state law that says anyone who has 160 acres parcel can hunt elk without a permit because they are considered a nuisance species? That might be a fact you might want to look up, sir.
I'll get to that. It's personal knowledge, it sounds like, so I'll address that, what you just said, in a little bit. You next said, every year, for the public record, we issue thousands of hunting permits because these animals are on the verge of being called, quote, a nuisance according to the hunting guidelines. Again, Commissioner Lovall is testifying as to the low importance of elk habitat, Goal 5 and Policy 11. Again, this is essentially testimony in opposition to Policy 11 as currently interpreted. I won't go through it all again, but will you recuse yourself based on what I perceive to be that as bias? Thank you. That's another personal knowledge one. That's all I have for bias. And then personal knowledge is the next one. Commissioner Lovall, you just indicated that you have personal knowledge of some particular statute. Do you want to disclose the substance of that?
Which one are you referring to, Mr. Mullen?
The one you just referred to, the 160 acre.
Well, that's a state statute on a hunting guide. If you look that up on Oregon's hunting guide, yeah, that's there. I'm not sure exactly what page that's on. I could find it. It's in my notes or in the stack here, but.
It's personal knowledge, so if you could disclose the substance of it. I mean,
Well, it's personal knowledge if you're a hunter or if you're someone who's involved with hunting species around what's considered to be not an endangered species in the state of Oregon. Yes, sir.
you're aware of the elk.
Any hunter is aware of this statute, sure.
You're aware elk are protected under Goal 5.
They are advised to be protected. They aren't considered an endangered species. That was my point. And they're not considered an endangered species under Goal 5.
There are no endangered species under Goal 5.
Under Goal 5, correct.
Endangered species, ESA is a federal statute.
Sure.
Furthermore, again, you referred to these according to the hunting guidelines. Again, that's personal knowledge. I suppose you've answered that already. You also stated at that hearing, further, property owners have stated elk, deer, and mixed game come through and over their property regardless of any built obstructions they have. They come right through the fences or in their gardens, and they are ever-increasing numbers over the last 5 years. Can you disclose your personal knowledge of that they're ever-increasing in the past 5 years, where you got that?
That was from specifically Paul Westfall, as he's lived out in that property of then about 25 years before he moved. And it was also, like I said, in passing of casual conversations, people have noticed an increase in herds. People that I talk to who are hunters have noticed an increase in elk habitation and population. And more people I talk to don't go through hunting season empty-handed anymore, like they used to.
Okay, so that personal knowledge does not come from any sort of article, periodical, study, anything like that, just hearsay?
Sure, if you want to call it that, yeah, friends.
Sure. And I think I just have one more. You said the only thing that is going to prohibit that is a herd of elk coming through a property, is a 25-foot fence. Can you disclose to me where you got that personal knowledge?
That's just personal estimation just based on what I've seen out in the country and how elk do some damage when they come through a property.
Okay. Just make sure I've covered everything here. And then I'll just ask one more time, renewed request to Commissioner Farr to recuse himself based on bias, prejudgment, as well as animus. Animus. Remember that conversation?
That's the term that you use, it's the term I don't use, so.
Would you like me to review that, the substance of that?
You can do exactly what you wish to do, Mr. Malone, that's what you seem to be doing.
At the June 16th, 2023 hearing, you said that we all must, this is paraphrasing here, but the important words that you said is that we all should be afraid of Landwatch Lane County.
I'd have to see exactly what I said there and what context it was in.
I would just refer you to the June 16th, 2023, or our prior hearing in which I addressed this with you, but I find it difficult that Landwatch Lane County can be treated fairly, impartially, when you have stated from the podium to the public that we all must be afraid of Land Watch Lane County and what they will do. So again, I'm going to request that you recuse yourself based on animus, bias, prejudgment. Are you willing to do that?
No.
Thank you. Commissioner Senega, are you willing to recuse yourself based on bias and prejudgment?
No.
Thank you. Commissioner Lovall, are you willing to recuse yourself based on bias and prejudgment?
No, sir, Council Malone.
Thank you for your time.
Thank you, Councilor Malone. So if I'm understanding, the request is to keep the record open to the extent for, but you can work with our council to create a framework for the requested documents that be placed into the record to put into the record these disclosures and the content, the substantive content of these disclosures. Is that what we arrived at earlier?
Chair, if I may, County Council will draft a motion that the board can adopt or pass later, if that is their wish, to continue the hearing for this purpose of allowing rebuttal. And we will provide direction on where any communications that the commissioners want to submit, the official route for submitting that to get into the record. I think the other part of your question related to what is Ms. Council Malone's full objection. So obviously he would have to answer that. I don't think I need to coordinate with him at all. We just need to provide you the motion and guidance so that you understand what we recommend is the scope of what should be put into the record. But I would say if you can please also provide counsel online a chance to provide her advice as well.
Thank you. Does outside counsel have further guidance for us before we move on in the proceedings?
Not at this time. Thanks.
Thank you so much. Okay. Thank you, Mr. Malone. Your objections have been noted. Cost to submit written rebuttal. So I think if I'm following, this is also an opportunity then, Tanya, for you to see if there's anyone online who wishes to present any challenges to any member of the board's ability to hear this matter.
Thank you, Chair. I do see participants online, and if you would like to challenge, please raise your virtual hand at this time, and I will call on you if you would like to challenge the commissioner's ability. I do not see any virtual hands raised at this time. I do see someone that is in with a phone number, and I don't think that they are allowed to raise their hands. So I'm going to let them unmute. I'm going to let them unmute. So the caller that ends in 7753, are you wanting to, I see you're unmuted. Would you like to challenge the commissioner's ability here? We cannot hear you, but I do show you're unmuted. Well, I cannot hear them, so I don't see any other hands raised. So I'll return it back to you.
Okay, thank you. So if I could just have some guidance on the script, it looks like then we are at the staff presentation portion. Is that correct? Have I missed anything in the?
I need a second.
We've had challenges raised with an explanation of the basis for the challenge.
Yes, that is where we are currently.
Request to submit written rebuttal to the substance. That's what we're have a motion for. Great. So then we are at the staff report. So I will welcome Shauna Adams to introduce the documents that are before us and provide a report and any presentation you have prepared for us. Thank you.
Thank you, and good afternoon, Chair Traeger, Commissioners. Again, for the record, I'm Shauna Adams, Staff Planner, and the matter before you is a continued on-the-record hearing from April 16th for board review of 3 hearings official decisions denying individual forest template dwellings in the F2 impacted forest zone. Each of the 3 applications propose a template dwelling on a parcel of less than 14 acres in designated major big game habitat adjacent to the Oak Ridge Airport. All three were elevated to the hearings official for an initial decision with a staff recommendation for approval. It should be noted that staff's recommendation for approval was based on the applicant's initial arguments related to needed housing statutes that LUBA and the Court of Appeals has since found to be unlawful and unfounded. All three template dwelling proposals were denied by the hearings official solely based on a failure to satisfy Lane Code Rural Comprehensive Plan Goal 5 Flora and Fauna Policy 11, or Policy 11 in short. Today, and I will advance the slide and advance again. Today, I'll provide a summary review of the process, the record, the key issues that were covered in more detail in staff's April 16th presentation, and will review possible options for board action that would occur following the close of the record. The text of Policy 11 has been provided in the presentation slide for reference before you. The majority of Lane County is governed by Lane Code the Lane County Rural Comprehensive Plan, or the RCP in short, which was initially adopted and acknowledged by the state to comply with statewide planning goals in 1984. Policy 11 is a part of the Lane County's adopted and acknowledged program for big game habitat protection to meet the requirements of Goal 5 within the RCP plan area. The board may recall that in 2021, the State Land Use Board of Appeals ruled in the Nimkish and King template dwelling appeals that the county must apply Policy 11 as a criterion for template dwelling applications in big game habitat, which was contrary to the historic practice and staff's historic understanding and the hearings official historic understanding that Policy 11 did not apply directly to forest template dwelling proposals. In effect, LUBA's rulings have been understood to mean that forest template dwellings cannot be approved on tracts smaller than 80 acres in major big game habitat or smaller than 40 acres in peripheral big game habitat, absent further justification under state Goal 5, the statewide Goal 5 rule via a comprehensive plan amendment. LUBA's holdings prompted the Home Builders Association to propose that the board adopt a local interpretation of Policy 11, contrary to LUBA's holding in 2022, and prompted the board to consider whether to update the county's adopted Goal 5 program for big game habitat protections or to make a local interpretation of Policy 11 contrary to LUBA's holdings. Most relevant for this matter now before the board, at their June 13th, 2023 meeting, the board opted not to pursue a local interpretation of Policy 11 at that time, but instead directed staff to do two things. One, to scope what would be involved in updating the county's Goal 5 program for big game habitat protections, and two, in the interim, to elevate the next relevant hearings official decision involving Policy 11 for the board to reconsider whether or not to make a local interpretation of Policy 11 then. According to the board's directive and Lane Code procedures, staff requested board review of the hearings official decisions before you now via an on-the-record hearing. On January 30th, the board adopted the board order to hold that hearing on March 19th. And on March 19th, that hearing was postponed to April 16th, 2024. After that, holding that hearing, during the hearing, staff provided a summary of the hearings official record, and the applicant provided their statements. And then the board passed a motion to continue the hearing to allow parties as defined in Lane Code Chapter 14 to present oral argument limited to the hearings official record and limited to Policy 11 and its interpretation, which is what brings us here today. The legislative history for Policy 11 in the hearings official record indicates that residential dwelling conflicts with big game habitat were expected to be unlikely on account of the dwelling restrictions in farm and forest zones that existed at the time, and for other reasons. Historically, staff has understood that Policy 11 density standards do not apply to template dwelling proposals. The parties in this matter appear to agree that the question of whether Policy 11 applies to template dwelling proposals was first raised before the Land Use Board of Appeals, or LUBA, in the Nimkish and King appeals. LUBA found that the historical interpretation of Policy 11 by staff and the hearings official did not bear up to scrutiny based on the policy text, legislative history, context, and the purpose of the policy. And the parties appear to, and on there, the parties appeared to agree that LUBA's holding are binding on the planning director and the hearings official. 2 of the 3 proposals before you today involve the same properties and substantially the same proposals that were denied under LUBA's 2021 King holding. The applicant has asserted that the board is not bound in the same way to LUBA's holding in Nimkish and King, and that LUBA would be required to defer to an interpretation to the contrary made by the board because it would be legally plausible. Three possible interpretations of Policy 11 were presented and considered by the hearings official. These include the applicant's proposed interpretation for adoption by the board. That interpretation is substantially the same interpretation that was rejected by LUBA and Nimkish and King and proposed by the home builders in 2022, again with the expectation that LUBA would be obligated to defer to that interpretation if it were adopted by the board. In anticipation that the hearings official decisions would be elevated for review, the applicant did ask the hearings official to allow the applicant and parties time to create the record that they believed would be necessary for full consideration of the policy and interpretations by the board. The hearings official granted that request via extended record periods, and the applicant provided a final proposed interpretation intended for board adoption in conjunction with their final arguments. The proposed interpretation is provided as an attachment to the March 19, 2024 agenda cover memo. In short, the applicant argues that Policy 11 is in its entirety is intended to address future planning work in a regional approach that is yet to happen. It was not intended to apply to dwelling proposals in the F2 zone. For the F2 zone and dwelling proposals, the applicant contends that the legislative history shows that the county abandoned big game protection via ODFW density recommendations and lot size minimums for big game habitat protection in favor of stronger siting standards with clustering, and that these F2 zone provisions alone satisfy Goal 5 big game habitat protections. Opponents to the proposed applications advocated for LUBA's interpretation of Policy 11. LUBA concluded that there's nothing in the policy text, legislative history, and context to indicate that Policy 11 is so limited or to support the applicant's arguments. Per LUBA, the history and context shows that F2 siting standards were intended to supplement the Policy 11 density standards. Moreover, they show that Policy 11 would be satisfied if the ODFW recommendation for overall residential density is satisfied, which LUBA understood to be a density of 1 dwelling per 80 acres or per 40 acres, depending on the big game habitat classification. The hearings official also considered an alternative policy to interpretation that was offered by staff. That interpretation is generally in keeping with LUBA's interpretation, except that it goes on to analyze the specifics of how the F2 siting standards were intended to supplement Policy 11 and recognizes that the ODFW recommendations on overall residential density that are referenced in Policy 11 are not limited to ODFW's, the Oregon Department of Fish and Wildlife's, 80 and 40 acre threshold, but they also include another standard, which is a standard where clustering is required, which would allow for dwellings on properties that are half that size with 40 or 20 acres, depending on the habitat classification, provided that the F2 siting standards are met. Staff's analysis of the evidence that gave rise to this alternative is based on a review of the information in the LUBA records for King and Nimkish and some newly discovered evidence in the record. The staff analysis was provided in the staff report to the hearings official and speaks to the merits of the interpretation. The hearings official incorporated the analysis by reference in her decisions, which are included with the updated draft board orders in the October 1st, 2024 supplemental agenda cover memo. Staff would highlight that the staff alternative was provided in support of the applicant's needed housing argument and for consideration by the hearings official and the board upon review, rather than as a proposal in a format with findings for board adoption. A more detailed summary of the three identified interpretations addressed by the hearings official was provided in the March 19th, 2024 agenda cover memorandum and staff's April 16th presentation slides. I have those slides available today for reference if any questions arise. A key takeaway to keep in mind for this matter is that the only policy 11 interpretation considered by the hearings official that might allow for reversal and approval of the subject template dwelling applications would be the applicant's proposed interpretation. The hearings official decisions, again, can be found in the board packet and the agenda cover memorandum for this continued hearing. The denials are generally in keeping with the hearings official decisions for the 2020 King filings and Luba's King holding. Under the deferential standard of review that would be afforded to the board, if the board's decision were challenged, Luba would be obligated to defer to the board's interpretation of its own policy, in as much as it's legally plausible, meaning that the interpretation is consistent with the policy's express language, apparent purpose, underlying policy basis, and the interpretation is not contrary to state laws that the policy is intended to implement. The hearings official largely agreed with the applicants that Luba is not bound to Luba's holdings in the same way as staff and the hearings official, and that Luba would be required to defer to the board's interpretation of its own policy, again, in as much as that interpretation is legally plausible. However, the hearings official also raises concerns that Luba would not likely affirm an interpretation made by the board that does not fully implement ODFW's recommended densities as required by Policy 11. In anticipation that the board would review the hearings official decisions and make a local interpretation of Policy 11, and to assist the board in that effort, the hearings official does provide an interpretation of Policy 11 that reflects their evaluation of the evidentiary record. In the hearings official's review, Policy 11 serves to fill a hole regarding Goal 5 protections that was left because the county code did not have minimum lot size requirements for the placement of a dwelling. It should be noted that the hearings official interpretation is generally consistent with Luba's holding, except that it also is understood to endorse the alternative staff interpretation that recognizes Policy 11 allows for forest template dwellings on 40-acre parcels in major big game habitat or 20-acre parcels in peripheral big game habitat when clustering standards are required. However, the hearings official does not elaborate on the staff analysis or directly address the objections that were raised by Land Watch, Lane County, and Thousand Friends of Oregon concerning that interpretation, at least not in a manner that readily allows for the board to ratify the interpretation without further clarifications and findings. In any case, the proposed template dwellings would not meet density standards on properties that are less than 40 acres in major big game habitat, as we have for these three applications. Staff has provided the board with updated board orders and motion options for today's continued hearing in the supplemental agenda cover memorandum. These are also on the screen before you. Unless you'd rather than I not, I'll speak to them. I would note that if the board does pass a motion that would continue this hearing, these would be options to consider after the close of that continued hearing. Should the board choose to make a local interpretation of Policy 11, that task entails determining what the county and the state intended at the time the RCP was acknowledged in 1984. The pivotal question is whether Policy 11 density thresholds are correctly interpreted to apply directly to template dwelling proposals. As was the case for Nimkish and King, that answer largely pivots on whether the F2 zone siting standards and lot area standards codified in Land Code 16-11 were adopted and acknowledged to supplement or to fully carry out and replace Policy 11 density standards for forest template dwelling proposals. If the board were to find Policy 11 is correctly interpreted to apply to template dwelling proposals in keeping with LUBA's holding, the secondary question would be, that would not be a deciding factor for these applications, but could be for other proposals, would be what that Policy 11 density threshold is, and more specifically, whether the Policy 11 density threshold was intended to allow template dwellings, meaning the F2 zone siting standards on parcels that are 40 or 20 acres in size, rather than 80 or 40 acres in size. If the board, if the board were to find Policy 11, give me a moment. Under option 1, so now I'll talk about the options before you. Under option 1, the board could choose to approve the board orders to affirm the hearings official's decisions, which expressly remain silent on the interpretations made by the hearings official. So if the board orders are written to affirm the hearings official's decision and to make no local interpretation. Under option 2, the board could choose to affirm the hearings official and revise the orders to make a local interpretation, either to ratify the hearings official's decision interpretation or modify that in some way. Under option 3, if the board opts to adopt a local interpretation of Policy 11 and concludes that Policy 11 was not meant to apply as an approval standard for forest template dwellings, this will have the effect of reversing the hearings official's denials and will necessitate that the board decide whether to conditionally approve or deny the applications based on the balance of the other criteria which the hearings official did find in her decisions to be met. Staff has recommended for that, before I move on to staff's recommendation, I'll say that for option 3, for a reversal, the applicant has already presented its proposed interpretation in a final format for board adoption. And moving on to staff's recommendation, just to remind the board, staff has recommended option 1 or option 2 after careful consideration of the record, the hearings official's decisions, LUBA's holdings, and the standard of review that's applicable to board decisions. Staff is mindful that on their June 13th, 2023 meeting, the board directed staff to elevate the next relevant decision involving Policy 11 for the board to consider whether or not to make a local interpretation of Policy 11 in anticipation that the board might not opt to do so at all in that context, or might choose to do so with a future application that is elevated before it. Should the board believe that the evidence and arguments presented in the hearings official record are insufficient or not yet ripe for review or adopting a local interpretations via this proceeding, then option 1 would be the course for deferring the interpretation. That concludes my presentation unless you have questions for me.
Thank you so much, Shauna. Any questions from the board? And my only question, it seems like just a semantic, the motion language in our board packet is essentially these, just slightly reworded, but
Okay.
we will be using, should we get to that point, the language in the published agenda items, just to make sure, because we don't have these slides in front of us.
Thank you for highlighting that.
Yeah, they're very, very slight and semantic, but just if anybody's watching and they're seeing what's on the screen, it's different than what's in the published packet, so just want to make sure that's clear. And so that when or if we get to that, if a board member wishes to use the language, we should use what's in the published agenda, I think. Is that right? So no questions from the board for staff? Okay. Then, it is now time for the applicant and applicant's representative to provide their oral testimony to the board on Policy 11 and its interpretation based on the hearing's official record. So we have 3 separate sign-in sheets, and when I call your name, you can come to the podium. Tanya, will you prepare us with a clock on the wall, please?
Could I start with a
And,
procedural request?
Excuse me?
Just to make before we get to the merits, could I raise a procedural point?
Not at this time. I'm in the midst of setting up this portion of the proceeding, sir. Tanya, could you bring a clock up, please?
Are you wanting 3 minutes? Is that the amount of time?
Yes, please. I believe, or is this 5? This one's 5, right? Thank you. So we have separated out, first we will receive testimony from folks in favor, then neutral parties, and then folks in opposition. When I call your name, you may come to the podium and state your name for the record, and then I'll ask you to pause. So Tanya, once the clock is up, please don't start it with the name statement, because I'll just have staff affirm that this person is eligible to present testimony, and then we'll have them begin their testimony.
Do you not see the clock?
Oh, no, Sean, I think maybe does Sean have to take down the presentation for us to see the clock here? There we go.
Yeah.
I have to stop sharing.
Thank you. Give us just a second. Okay, now try again, Tanya. So the first person I have signed up to give comment in favor is Bill Close. Ms. Adams, is he eligible to present? He is, and so Mr. Close, when you state your name for the record, your 5 minutes will begin.
Bill Close. Before I start on the merits, may I make a comment off the clock in response to Mr. Malone's examination of commissioners? And on account of my name was mentioned 12 points.
Yeah, not at this time, sir. This is your opportunity to have 5 minutes to present your testimony in support of the applications.
Thank you. I understand the record's left open for continuing information about the ex-parte contacts, so I will join in that open record period and make my point. Commissioners, thank you for continuing this hearing and ensuring we did not get into the merits last hearing, which would have left us in a mess and would have ensured that we'd all be back here right where we're at right now, 9 months from now after an appeal to LUBA. I really appreciate that. Commissioners, this is not as complex as it has been made out to be, I assure you. What I would like to end up with is the board voting tentatively to restore the rules for forest template dwellings back to the way they were from 1984 to 2021. And as a matter of policy, because this is a time for you to make policy, to resolve, interpret ambiguous plan language, and to suggest to the applicant that we bring back to the staff, county council, and ultimately the board, draft findings to support your restoring that original policy. That's what I'm asking you to do. This is your opportunity to make policy. LUBA has said that the first sentence of that Plan Policy 11 is ambiguous. Oregon Department of Fish and Wildlife recommendations on overall residential density for protection of big game shall be used to determine allowable number of residential units within regions of the county. There's no acreage information in there. There's no acreage information, no acreage minimums anywhere in the plan or code. LUBA says that is an ambiguous policy sentence. Here's what LUBA said in King 1. Policy 11 is ambiguous and requires interpretation to determine whether and how its density limitations function as approval criteria for a dwelling permit application. That's it. LUBA got it right. So the moment LUBA says what's obvious, which is that policy sentence is ambiguous, the door is open for you to interpret it. That's your job. In King 1, we were dealing with that sentence. The hearings official had to deny the application because hearings official had to apply LUBA's interpretation. And we tried to get the director to get that to you so you could do in King 1 what you're doing now in King 2. The director didn't want to get the issue to you, wanted to keep the door closed to you. LMD wanted to make policy by implementing LUBA's interpretation, not letting you do your own. Well, finally, courtesy of folks after King 1 going to the board and saying, this is really important, the board adopted its order to staff saying, next time you see one of these rascals, you bring it to us on appeal. And that's why we're here right now. So that's the issue. I have a whole 2 minutes left. The key point to make is this. Because it's ambiguous, as a matter of law, it means there are at least 2 plausible interpretations. LUBA said that. That's the definition of an ambiguity. So with LUBA saying there are multiple plausible interpretations here, LUBA said, the way we apply the rules, we don't defer to the local government hearings official, so we interpret it this way. And they read the acreage minimums into that sentence. But LUBA was also saying, because it's ambiguous, there's an alternate interpretation as well. LUBA didn't talk about what it was, but by definition, because it's ambiguous, there are multiple plausible interpretations. All we're suggesting is that one of the plausible interpretations is the acreage limits do not get read into that first sentence. And if you make that finding, if you say that's what our interpretation is going to be, that is merely saying we are restoring county policy to exactly the way it was from 1984 to 2021. And because that's a plausible interpretation, it's completely possible for you to draft findings that support that conclusion. Please don't defer the drafting of findings to support that conclusion to staff. Option 3 says, if you want to reverse this and go back to the good old days, we'll draft findings for you. Please let the applicant draft the findings. Nobody, the staff doesn't like that interpretation. Nobody who doesn't like the interpretation should be given the job of drafting findings that support the interpretation. I look forward to a short reply when we get to that time. Thank you very much.
Thank you for your comment. Next up is, looks like Chris Letourneau. Please correct me. Apologies if I mispronounced your name or misinterpreted your handwriting. Please welcome to the podium. State your name for the record, and your 5 minutes will begin.
Yeah, my name is Chris Letourneau. I'm a homeowner, contractor here locally, small. And I just want to say how this has impacted lots of families. And we really need to, you guys have an opportunity for the people.
Pardon me, sir. I'm sorry. Oh, okay, sorry. I realized I skipped the step of just affirming with staff that you're eligible to speak. My apologies. Please continue.
Okay. So you guys have an opportunity today to help the people and create housing and do something that's meaningful in our community today. And so I'd ask each one of you to step up and do the right thing and elect to put the template dwellings back to where they were currently. And then that would give staff enough time to rewrite the laws and do it the right way, not just hurry through the process or do something short-sighted. We shouldn't have to make quick decisions when they're not needed, and I think there's a due process that could be, we have an opportunity to take now and not just kick the can down the road. As for, the elk and their habitat, I'd like to ask Parks and Rec, how many damage control permits do they give out?
Excuse me, sir. Sorry, I'm just checking with staff. This is a very limited scope hearing that is to speak only to the applications. And so I'm just checking in about scope.
Specific to policy 11 and its interpretation in the record.
I just wasn't sure if I was interpreting. Pardon us, this is a different proceeding, and I want to make sure that we're following, that we're doing it properly. And so I wasn't sure if I was interpreting your signals to me, Shauna, whether you were having concerns whether this was going outside the scope. Maybe I was misinterpreting.
Clock running.
Oh, we'll reset
Wanted
your
to
time.
flag
Thank
the
you for that, Commissioner. I'm sorry, say again, Shauna?
I just wanted to flag the question for you. It wasn't clear to me that the testimony was addressing policy 11 and its interpretation.
Tanya, can you put back some time on the clock?
I could only reset it to 5. Do we want to, I can make a 4 if you want me to.
That would be
switch
great,
to
thank
4.
you. Thank you
Okay,
so
hang on.
much.
So.
My apologies, sir. Give us just a moment. Thanks for bearing with us. So again, I'm just, while we're waiting for that, looking for, writing on the back of it. There we go. Thank you again. Please go ahead, Mr. Letourneau.
Yeah. So as for how many how many permits for damage control permits get approved yearly for large game is pretty significant on most properties. We're talking about a species that's not endangered and has impact to, all farmers and F2 zone for either tree farms, farming, and all those things. In policy 11, we're talking about minimum standards. We want to do more density, and that's why there's clustering requirements already in the previous code, so we don't impact, our land and our habitat that well. My subject piece of property is 8 acres, and it's completely surrounded 360 degrees by housing. And there's no opportunity.
Sorry, Shauna, is that a concern about scope of the comments to the application?
It might be helpful.
Please
to-
pause the clock, Tanya.
This is a very large record, and I apologize for not having it all in my head, but it's not clear to me that the testimony is addressing facts in the record, not introducing new facts. So it might be helpful for participants to direct the board to the information in the record.
Thank you. So, Mr. Letourneau, can you cite what part of the record your comments specifically relate to?
Not off the top of my head.
Council, did you want to add anything?
It's okay.
Okay. Yeah, that is a challenge, as we're continuing building on a record that's rather voluminous and very specific in scope, that this is, that the comments really need to speak directly to something already in the record that, and what was made available to the hearings official. So if what you're presenting was not part of that record, and it's not part of the scope today.
Unless I'm.
Chair, if I may, I would add, we don't have to necessarily restrict his testimony to say, pointing to the record, he's allowed to make his points, but it does have to be tailored towards policy 11 and its interpretation. And if it's clear that it's not, Ms. Adams will flag it. If it's not absolutely clear, I recommend erring on the side of allowing it, and then the board can address in their findings what testimony is submitted that's outside the scope, and that the board will not consider that in its decision.
Thank you, that's helpful. And again, my apologies, and thank you for your patience. And I'll just ask staff, I know she's busily scanning through the record, but also just to be really definitive, if you're asking me to pause the proceedings rather than just checking with me that you see that I see you, that would be really helpful to our guests. So thank you. Once again, my apologies.
Okay.
Please continue. Thank you, Tanya, with the clock.
So in policy 11, it calls out now having standards where the lot size has to be 40 or 80 for the big game overlay, and the previous one where we could have smaller lots is what I'm stating is much more better for both the big game habitat and housing and the people around that, because now we're trying to have density within those areas and not trying to go out into a single home out into 120 acres type track. So I feel that in policy 11, the way that it was previously is a much better use of the land and, how we should be looking at it for both the elk and for human habitat in those areas. I'd also like to say thank you guys for, being up here. I can see that it's a difficult position and just want to give you guys a little bit of credit for all the work that you guys do. Thank you.
Thank you for your comment. Tanya, will you please check and see, we can reset the clock to 5, and then see if there's anyone online who wishes to present testimony in favor of the applications.
Yes, give me a second here. Got a lot of screens happening. Anyone that is attending virtually that would like to speak now, please raise your virtual hand. Okay, I do not see any virtual hands raised for this time to speak, so I'll return the meeting to you, Chair.
Thank you. And at this time, we will move on and receive testimony. I see no one signed up in a neutral position, and we have 5 names signed up in opposition. And so again, when I call your name, you can step to the podium, state your name for the record. Your 5 minutes will begin. And please, again, be sure to limit your comments to the hearing's official record and limited within that to Policy 11 and its interpretation. And that is Policy 11 in the Lane County Rural Comprehensive Plan, Goal 5, Flora and Fauna. And so first up is Sean Malone, who will be followed by Hope Vacker.
Thank you again. Sean Malone on behalf of Landwatch Lane County. So we have to ask ourselves, why are we here? And that's because the Court of Appeals and the Land Use Board of Appeals have now prohibited any forest template dwellings on F2 land. As Commissioner Lovall said, according to his constituent, either Westfall or Basaraba, that what they thought of as a buildable parcel of land is no longer. Complete prohibition. Commissioner Lovall also noted that, again, I assume on behalf of Basaraba or Westfall, because that's the only people I've heard, but all of a sudden now they can't build on this property for the reason undetermined. Again, a complete prohibition of forest template dwellings on F2 land. Well, actually, that's not true at all now, is it? There is no prohibition on template dwellings on F2 land. There is just a simple additional step. And so it's rather remarkable to me that all of this has to do with a single additional step. And a dangerous game is being played here, where people are feeding other people this notion that there's a complete prohibition on building template dwellings on F2 land. I hope Commissioners Lovall, Commissioner Senega, Commissioner Farr, Commissioner Trieger, and Commissioner Buck review the hearing video, audio, either or, before the hearing's official. Because an individual came in who was fed information that he had a parcel of land in Lane County on F2 land that he was completely prohibited from building. The man was, I'm not gonna say his name because it was intense. I've never seen a person like that at a land use hearing. He was emotional. He was on the verge of crying because he thought he had lost everything. He had to leave the room afterward because he was so distraught. And it was a lie. He was lied to. All he had to do is do one extra step, and he could get what he wanted. It blows my mind that these sort of orchestrations and manipulations are occurring here. The drama that is played out here is just untrue. It's not grounded in fact. So we need to start to begin to be honest that all people need to do is do an additional step, and they can have their template dwelling. Comply with the EC analysis. And that's something that both staff, LUBA, Court of Appeals, hearings official, Landwatch Lane County, we all agree on. All you gotta do is the EC analysis and you're good. So, there are a lot of lies in politics these days, big lies. And it's difficult to fathom because you're taking advantage of people who may not understand it all. And then they get extremely emotional, they do intense things. And so I think we need to step back and begin to be honest with our constituents property owners, applicants, and not feed them lies. And so hopefully you've come to that understanding, because staff presented, what we all know, you just have to do an EC analysis. As to this notion of deference that it seems like everyone thinks they're gonna get before LUBA and the Court of Appeals, there's something called acknowledgement. The Board of Commissioners presented their comprehensive plan in 1984 and the years prior to LCDC and DLCD to try and get their comprehensive plan acknowledged. That acknowledgement was based on Policy 11, Goal 5. It was approved by ODF and W. And you don't get deference on that issue. So you're dealing with state law at that time. You're dealing with acknowledgement. So this deference notion that has been sold to you is not true. And again, I think this has all sort of just been kind of wasted time, because you're being sold a bill of goods. So I really don't have anything more to say. Again, I agree with staff's position to a degree with regard to the EC analysis. I agree with LUBA, Court of Appeals, and the hearings official. So in that sense, I would ask that you affirm the hearings official's decision. Thank you.
Thank you for your public comment. I'll ask staff to affirm. Hope Thacker is, then please come to the podium. Not providing testimony, okay, thank you. Then I would call Joe Stark. Is he in the room? Great, thank you. And is Joe Stark allowable? Thank you.
It's Joe Stack.
Stack, thank you, my apologies. Welcome, please state your name for the record, and when you do, your time will begin.
Chair Trieger, other members of the commission, thank you for providing the opportunity to speak today. For the record, my name is Joe Stack. I am the regional habitat biologist for the Oregon Department of Fish and Wildlife, covering the South Willamette watershed, which includes Lane, Lynn, Benton, Marion, and Polk counties. ODFW's mission is to protect and enhance Oregon's fish and wildlife and their habitats for use and enjoyment for present and future generations. The department appreciates the opportunity to provide comments. The department's recommended dwelling density for major big game habitat is 1 unit per 80 acres, or with clustering, 1 unit per 40 acres. The department evaluates dwelling density by using a dwelling per acre approach, where each parcel tax lot is viewed on its own to see if it meets the qualifications. While utilizing clustering standards could allow for development of a 40-acre property in major big game habitat, tax lots associated with these applications are significantly smaller, being approximately 12 to 13 acres in size. The department relies on local and state compliance with the land use planning goals to consider natural resources such as big game habitat. The addition of clustering and siting standards for forest dwellings should be seen as supplementary to the department's density recommendations, with the ultimate goal of providing the highest amount of protection for big game. It is uncommon that a single development action would have a critical impact on big game. However, development has a cumulative effect on wildlife habitat and associated wildlife populations, as well as many other natural resource and social issues important to Oregonians and the residents of Lane County. It was the need to plan and account for these cumulative impacts that resulted in the development of the RCP. Loss of habitat can have adverse effects on wildlife species, with the potential for localized population decline and an increase in human-wildlife conflicts. Existing or proposed non-forest or non-farm dwellings within the forest land district must recognize that the intent of the district is to protect resources, and that in the event of a conflict, this chapter will be interpreted in favor of resource management practices. Big game should be considered a resource similar to timber, where game species are managed to provide opportunities to the public. In 2019 alone, hunting and wildlife watching provided significant economic benefit to Lane County.
Pardon me, just
Chair Trieger.
pause the clock, please, Tanya. I'm just checking on something procedurally.
I just want to note that the testimony I'm hearing does appear to be the same testimony that's in the record, But what's unclear to me if it is all relevant to the question of interpreting policy 11 as it was, how it was, policy 11 in its interpretation as it was adopted in 1984.
Thank you. Can you speak to that, Mr. Stark?
I mean, I can remove that if there's question on that, so.
Thank you.
I think it just supports the thought of big game as a resource, which is.
Start the
something
clock again, Tanya.
Important to hear. Good, okay. ODFW acknowledges the challenges that arise when trying to balance community values regarding resource protection, economic development, and social considerations. There needs to be careful and thoughtful land use decisions that balance economic growth while conserving and protecting Oregon's natural resources for present and future generations. ODFW is committed to finding collaborative solutions as the county evaluates how to address the conflicting uses to big game habitat. Thank you for your time.
Thank you for your comment. I have two other people on the sign-in, but I'm seeing now maybe some people signed in just to indicate presence. Is there a, looks like Laurie Seagull, not providing testimony, thank you. Don Kenyon, is Don not providing testimony, but on the, okay. That is the end of the sign-in sheet. Tanya, is there anyone online wishing to present before the board in opposition to the applications?
Thank you, Chair. For those that are attending online, would you like to speak in opposition? If you would like to, please raise your virtual hand. For the person who called in with the last digit 7753, I do there you're unmuted. Would you like to give opposition? Not sure why we are not connecting and hearing your voice because I do show you're unmuted. I'm not sure what to do with this person, but I do not see any virtual hands raised for opposition.
And with someone on the phone, you're not able to put anything in a chat or something, are you? Right?
No.
So maybe just encourage that person if they were, their an email address or something, we provide them with information about, I mean, it's only oral testimony, so we can't ask them to email their comments. Welcome any.
They're unmuted as we are talking right now, and I do show that they don't have anything on my end that shows that they are not allowed to speak, that there should be no reason why they aren't allowed to speak.
Okay. Well, apologies to that person, but that is sounds like a technical challenge maybe on their end. Maybe there's an additional muting on their side that. All right. Well, then I think we just have to move on. Sorry, get reoriented to my script here. And again, thank you to everyone for your forbearance with us through this process. We are at testimony. Other parties in favor, opposed, opposed, opposed. Any additional statements from the planning director or their designee is where we are in the script at this time. Item 7.
I just have a few statements in response to Mr. Close's and Mr. Malone's testimony.
Thank you.
Based on what's in the record. Mr. Close indicated that his hope was that the commissioners would restore the rules that previously applied for forest template dwellings since 1984. I just want to clarify that policy 11 has not changed since 1984. It remains the same. This is a matter of how to interpret the policy, and that forest template dwellings weren't allowed in the F2 zone in forest lands at all by state law until 1993, and weren't allowed in the county's F2 zone until the early 2000s. The applicant also mentioned that the task before the board is to make policy, I'd clarify that the task before the board is to interpret policy as it was, and what that policy was understood to mean in 1984 by the board and the state when the comprehensive plan was acknowledged. Lastly, the applicant urged the board not to defer the findings and allow for staff to prepare the findings. I want to remind the board that the applicant in their final rebuttal did provide and package an interpretation and finalized interpretation. They drafted that for the board's adoption, so that shouldn't be an issue, at least with respect to an interpretation of policy 11, should the board wish to adopt the proposed policy by the applicant. With respect to Mr. Malone's testimony, Mr. Malone referenced the hearing before the hearings official and emphasized that this policy 11, if the density threshold isn't met, does not mean that forest template dwellings are prohibited. It means that there's an extra step. And staff would agree that threshold in policy 11 needs to be met in the absence of further justification under the Goal 5 rule through comprehensive plan amendment in the EC process, which could occur by an applicant or could occur by the county. But as staff stated before the hearings official, it needs to be recognized that that's not a small step. It could involve a lot for individual applicants, and I want to recognize that. That's all I have to say, unless you have questions.
Thank you. So unless I am missing something, we have gotten through, now it has applicant's rebuttal on the script. To what are they rebutting?
That's what was in there to respond to anything stated.
Right. It was included in case the applicant or the applicant's representative wanted to respond to comments made. Yeah, Chair, did you have a question? for me?
Comments made in any point of the proceeding or specifically?
Comments made related to what other parties testified about.
To today's testimony?
To today's testimony, yes.
Thank you.
Within the same parameters for oral testimony for the hearing in general.
Thank you. So is there anyone who wishes to present any rebuttal to comments heard in today's testimony within the parameters of the scope of this hearing on behalf of the applicant?
Chair, my apologies, I wasn't clear. It's only for the applicant to provide the rebuttal, not for other parties.
A representative of the applicant?
Oh, yes,
Yeah.
that as well.
Thank you. And I see Mr. Close has taken the podium again, so, and do we have a time set for this?
5 minutes?
Staff? I'm asking staff. That's my question to
It
the
was a
staff.
suggestion.
Mr. Close, I understand, but I think we got this. Thank you.
I didn't hear that, I'm sorry.
How many minutes?
Oh, I would recommend the same 5 minutes.
Thank you. Tanya, would you please give us 5 minutes on the clock? Thank you. Please state your name for the record, and your 5 minutes will begin, sir.
Bill Close back on rebuttal. And I'll start with responding to Shauna's closing comments, because they're most recent in my mind. Shauna's totally right when she said, well, Bill said, we're asking for restoration to policies in place since 1984. And she said, we haven't had forest template dwellings since 1993. Of course. I'm sorry, I've only got 5 minutes. I got a lot of points to get in. Forest template dwellings started in 1993 to 2021, when the rules changed. Prior to 1993, the plan provided for dwellings in conjunction with forest use, and the same plan policies and code sections applied. It's just that forest template dwellings were the new and improved kid on the block starting in 1993. The suggestion that taking issue with my suggestion, this is your opportunity to make policy. She says, oh no, it's about interpreting policy. Of course that's right. But the point is, when you have an ambiguous policy and your job is to interpret it, and you have choices to make, you can choose this one, you can choose this one. Making the choice is creating policy. That's a policy choice. So it all boils down to semantics. I asked for the opportunity, if the board decides to restore the status quo ante, to suggest supportive findings. And staff said, he already suggested findings because he gave them to the hearings official. Please, at the close of the hearings official proceeding, I just suggested a policy interpretation with some draft findings. That it's not the hearings official's job to make the final policy choice for the county. The hearings official was stuck with the LUBA opinion. She then opined a bit about what she thought a good answer would be for the board. It's none of her business. I mean, that's your choice. Your decision gets deferred to, not the hearings official. Please don't hold, if you're willing to invite me to draft findings in support of your decision to restore the status quo ante, please don't hold me to something I gave the hearings official at one point in time. There's been a lot of staff work that's gone in since that time, materials presented to you. Staff has been able to give you a lot of written materials, a lot of argument, written argument justifying their position. I haven't been able to submit a single piece of paper. Here, I prepared for you 22 pages of suggested findings supporting restoration of the status quo ante. I can't give them to you because I'm not allowed to submit anything in writing. But if you decide to restore the status quo and you invite me to submit findings, remember that's okay because findings are not evidence. Findings are just findings. My suggesting findings are no different than staff suggesting findings. And I'm happy to tune these up, submit them to the county, reviewed by council, reviewed by staff, and eventually they'll make your way to you. I appreciate the comments of Mr. Stack from ODFW. Remember, he makes good points. It's always on the table for the county to revisit its Goal 5 program and change things, provide more protections for big game if that's what you want to do. That's a new policy choice. The question is today, what do you want the language from 1984 to mean? And that's a completely different question. I would just point out that when you roll the clock back and you're asking what was going on at that time, there was a single communication from ODFW to the County Board of Commissioners, a single document. And it was ODFW's advice to the County Board, a letter in June 1980. And here's what it said, quote, footnote 2, quote, the department's recommendations relate to overall residential density and not minimum lot size. So that's the only thing that the board told, that the ODFW told the board about this lot size issue. It does not relate to minimum lot size. It's about overall density. The county took that and said, okay, here's the way we're going to deal with overall density. 92% of all our forest lands, F1, off limits to housing. Nada. That leaves 8%, F2, and we'll let people have houses on those if they meet the standards, notwithstanding that, the acreage size. I feel really constrained with 2 5-minute chunks of time. Appreciate the chance to talk to you. This is a very big issue. Good luck.
So at this time, I will close the presentation portion of the hearing and move to deliberation and decision. And council has prepared the following motion, but council, do we have an amended or a revised motion based on the earlier conversation around disclosures?
Yes, and if I can also, before I provide proposed motions that the board can use, if I can also discuss a little bit procedural about what to do next, if I may.
Please.
Okay. So if the board chooses to do a continued hearing, I have draft motion, and then I will need direction on what scope you would like that continued hearing to entail, and if you'd like to keep the record open. And then aside from the continued hearing and what that motion should be, procedurally, the board can still continue with deliberations on the substance if they like during this hearing, even if they are going to do a continued hearing. Or you can choose to deliberate now, but I recommend not making any decisions or motions on policy 11 until after there's been a resolution of the challenges to the disclosures that were made. So that's, I will read, trying to think of the best order for this. So what I heard today was there was a desire to possibly continue the hearing to allow for commissioners to submit written materials to provide their necessary disclosures. So that is my understanding, that commissioners may choose to want to provide that in writing. And then there's also the allowing parties to challenge what is written. And then there's also someone raised if parties can submit draft findings for the board to use. And so I have motions for those different things, but if the board does choose to allow for draft findings to be submitted, the board would also have to make a motion for limited additional testimony specific to allowing parties to submit findings to the board, which is allowed under the procedure under Lane Code 1408 5C2, but there's certain findings that need to be adopted if you're going to allow additional limited testimony, which would be the written findings that parties want to submit. So I need direction from whoever wants to make a motion on kind of what the scope is, and then I can provide the legal language needed. But I also have one other point related to if we're going to reopen the record, to allow enough time for the board to make the disclosures and to get any legal counsel as needed, and to allow people time to rebut and then the commissioners to review the rebuttals. I have 2 hearing dates that are available, which would be November 12th, which would only provide the commissioners about a week to review rebuttal material before having the continued hearing, or December 3rd, which is a significant amount of time from now, but it would provide a lot of time for consideration of different things.
Thank you for that, Council. So if I understand, to recap, I mean, there's sort of 2 or 3 options, and each have an A and a B. So first, start with one of the simplest options, which would be to not have any deliberation today and make a motion to continue the hearing with a motion and a second motion with the language needed to satisfy producing materials for the disclosures. Is that right?
I would recommend a combined motion, and so I just need kind of head nods or someone to take the initiative to let me know related to continuing the hearing for disclosures, the date, but that's not as critical, and then parties' findings. And then for deliberations, that's just a matter for you to find out from the other commissioners if you want to do the deliberation. It doesn't play into the motion that I would be recommending.
So are you, sorry again,
okay.
and I'm just imagining if I'm a little confused, there might at least be one other commissioner up here who is maybe unclear what our options are. Maybe just informally, nobody's being held to anything. Can I just see if, to continue down the road of ensuring whatever we do next, it allows for time for commissioners to produce materials that satisfy the disclosures to satisfy the challenges. Is that something that commissioners want to ensure we provide time for, regardless of what else, deliberations or no, findings or no?
Provided we know what it is we need to provide.
Yes, of course. We will make sure
it's
that it is,
really unclear.
we will make sure that the parameters are clear so that you can actually satisfy that.
Is there any discussion to that, or we just
So-
haven't had nods?
Well, I think I'm just trying to figure out what the right motion is, because then we can put a motion on the table and discuss the motion.
I have a motion.
I
Excuse me, just a moment, please. I would,
thought I had the floor. Sorry, Chair.
yeah. Because I'm understanding council is suggesting a combined motion that allows time for the disclosures to satisfy the challenges and keeps the record open and sets another hearing date, but doesn't necessarily speak to the findings issue. That's separate, correct?
It would be a combined motion. I just need answers on those issues that you pointed out. Do you want to, okay, so I'll try to restate. So the first question, is there a desire for a continued hearing to allow for commissioners to submit written materials to provide, to further elaborate on the substance of the communications?
The challenges, right?
It's the commissioner's and I might want to defer to Council Tran Cafe in a moment, but it's the commissioner's responsibility to do the disclosures, and so it is also up to the commissioners to determine if they've made sufficient disclosures and if they're going to introduce additional information into the record. If you can possibly go to
Sure.
other council to talk about that issue, and then I can, still walk through the motions, but she can advise you on issues related to disclosures.
Is outside counsel available, listening in?
Yeah.
Great, thank you.
Okay, so the question is concerning making sure that the commissioners are providing the correct disclosures, is that?
I could restate the question that I was trying to defer to you. Related to if the commissioners want to do a continued hearing, I think the question is, do they want to do a continued hearing to allow, so that they can make additional disclosures? I think that's the question, since it is the commissioner's disclosures to make. It is their decision if they want to continue the hearing. And so I just like your feedback on that.
Yes, I agree that it's their decision to make. I think the form would be a motion to continue the hearing and reopen the record to allow those additional disclosures. And then it would be like legal counsel outside of the motion that would help them decide which disclosures they need to make.
So it's keeping the record open to allow disclosures, but not keeping the record open on the applications and the matter to be deliberated, right? That needs to be.
Right. None of the recommendations I have are to continue the hearing for purposes of continuing to discuss Policy 11 and its interpretation.
Right.
There are two. Admitting additional disclosures from commissioners in written rebuttal or challenges to the substance of such disclosures. That would be one. The other one is whether the board wants to omit proposed findings from the applicant under Lane Code 14080-5C2. And I said applicant, but I would say parties.
I have a motion.
Commissioner Farr.
Thank you, Chair. And I'll vote this motion. That is based upon your good advice, Council.
And if I may, if similar to the last proceeding on this matter, where you made the motion and then had council provide a little bit more clarity, if you make the motion, then I can make sure all the legalese are in there as well.
Thank you. Like 14.032, et cetera. Okay, good. And my motion, Chair, is I move to continue the public hearing and reopen the record to a date to be determined by council to allow compiling and submitting of disclosures by the Board of County Commissioners and for interested parties, and to allow interested parties to provide draft findings to support returning to pre-2021 status quo.
I have a clarification question for you. You said to allow parties to admit proposed findings, but then I did not understand the part pre-2021 status. I'm not,
Status quo, which is what was one of the testimonies were talked about, the pre-2021 status quo regarding F2 interpretation of template dwellings.
and so it's your desire for me to draft a motion that limits the type of findings that can be submitted to only that, correct?
That is the nature of my motion, yes.
Okay, Chair?
I have a question. Is this your advice that we combine these two matters into one motion rather than a motion to keep the hearing open to allow for
We can separate them.
supporting the disclosures, and then we have one whether to allow additional findings? In that, if that passes, then we have an extension, we've continued the hearing, then we can consider a motion whether to allow additional findings at that hearing.
And I crafted my motion based upon a suggestion that it be a single motion, but I'm okay
Okay.
with two separate motions.
And then if I can take a moment to confer with staff, if that's, so that I can help refine my motion.
Sure, and in any case, if you could, before you do that, deliberations, there could be some deliberations, but not to any motion today, and then continue deliberations at the continued hearing? Or would you recommend, if we continue the hearing, there be no deliberations today and they be reserved for that new hearing date?
I defer to the board. It is up to you if you'd like to do the deliberations. The key legal point is to not make a decision today, and so it is what your desire is to do in that case.
Thank you. So we do have a draft motion on the table. I could either call for a second or, and then discuss to the motion, or I could ask the maker of the motion if he wants to withdraw it to allow for consideration of two separate motions, and then maybe he wants to make those in turn.
And Ms.
to
Brown,
Commissioner
I'll ask for your advice on that, the second part of that. Should this be two separate motions? I understood your earlier advice was to combine it into a single motion, but I'm either way on that.
Based off hearing from the chair, I would recommend doing a second motion, and that allows the board opportunity to possibly pass one and not pass the other. And so if you want to make it separate.
And Chair, based on that suggestion, I will withdraw my motion and reintroduce it as two separate.
Thank you.
The first one will be to move to continue the public hearing to allow compiling and submitting of disclosures to a date to be determined by council. December 3rd was given as a possible date, and of course to reopen the record. That's the first motion is simply to this nebulous thing about disclosures, which I don't know what it is, but.
Thank you. I will take a moment to draft the motion if you can give me a minute or two.
Yes.
Thank you,
I'll
Councilor.
refine it. So, all right, the motion to reflect what Commissioner Farr has requested that I draft, I have to move to continue the hearing and reopen the record for the limited purpose of admitting additional disclosures from the commissioners and written rebuttal or challenges to the substance of such disclosures. These disclosures may include ex parte contact, personal knowledge, bias, or prejudgment. The commissioners shall submit any additional disclosures in writing by email to Shauna Adams, Senior Planner, at shauna.adams@lanecountyor.gov by October 22nd. The parties shall submit any rebuttal or challenges to such disclosures in writing by email to Shauna Adams, Senior Planner at shauna.adams@lanecountyor.gov by November 5th, at which time the record shall close.
That's exactly what I said.
And I need to pause real quick to see if there's additional language you need to include in the motion. Oh, there it is. I'm getting to that paragraph. The hearing shall be continued. The hearing shall be continued to a date and time to be determined in Harris Hall for deliberations following submittal of additional disclosures and written rebuttal or challenges. Sorry.
Certainly captures what I had intended, Council. Thank you.
That makes sense. It seems like it's a long motion, but it's essentially.
Did I not say that? Shauna is stating that I might not have mentioned the time. I might have. Can I rephrase the latter part, or do you want me to repeat the entire motion?
Well, we will need it properly in the record when we call for a vote, and then depending on the result of that, if it passes, it needs to be stated for the record, and Tanya will need it. And it seems a little, maybe I was misunderstanding, a little redundant, but it is essentially, you've named dates by which disclosures must be delivered, date by which they will be responded to for them to be considered resolved, and that once that date passes, the matter is to be considered resolved. Is that the upshot of the motion? I'm not asking that to be the new language.
The part that I needed to clarify was when the hearing will be continued to. So I provided the date. And Shauna, do you want to add? I am very sorry. I think that I'm going to need to redo the motion. Shauna, are you saying that we need to say a specific time for submitting of the rebuttals, and not just the date? We need the time.
Unless it's understood that the date's midnight, yes. A specific
Right.
date. Typically, it's close of business at 4 p.m. or 5 p.m. I'm just suggesting it be clarified, made clear in the motion.
Thank you. Great. So what I would like to suggest, if folks are open to this, is that we take a 5-minute recess to allow council to draft a motion that's as concise but clear as possible on this, and then also any other item that you've heard we might want to have a motion available to us around findings or not findings.
Question, Chair.
Yes.
Prior to the 5-minute break, what about a read of the second motion to see if there's some deliberation that needs to be made on that to clarify it?
Well, I'm not sure she's drafted that yet about whether to allow additional findings or not.
Is Commissioner Farr suggesting that I provide the motion for the findings right now?
No, that I would state the motion, and then that you would consider what it is that I've stated and make it understandable and practicable.
I think that's a good idea if Chair will allow.
Thank you, Commissioner, please.
Then the second motion would be to, once again, to reopen the record to allow interested parties to provide draft findings to support a return to pre-2021 status quo.
Okay, I have the direction. I can take the time to refine the motion and address the issue related to date and time.
Great, and I think, we will leave it to between you and Shauna. You understand the issue enough to, and I think what Commissioner Farr is trying to, based on what we heard today, what the intent of the motion is, even if that is not the language of the motion, and then we'll have a chance to wrestle with it a little bit.
I
Great.
completed law school in 2003, so.
Great. So let's see. Tanya, we are at 3:47 now. So math, let's say at 3:55. Just give us all just a minute to reload beverages and give staff time to craft a couple of motions and let everybody take a breath, and we will be back. We are recessed until 3:55 p.m. Welcome back. We are out of recess now and reconvening the meeting of the Board of Lane County Commissioners for Tuesday, October 8th, 4 p.m. We just took a brief recess, but we are still in the middle of item 10A, our Public Works item with a continued on-the-record hearing. And we paused to allow staff to provide a little bit of time to draft some motion language, and I will just note our administrator had to step away for another meeting, so our Public Works Director, Dan Hurley, is sitting in until he can return. And so does staff have some draft motion language that we could consider?
I have some, but I also have to ask clarification question in order to draft the second motion. Commissioner Farr, when you're wanting to allow parties to omit proposed findings into the record, you had a limitation on what that would be. And is that you are trying to limit the proposed findings to interpretations of Policy 11 based on pre-2021, or let's see, I'm trying to rephrase it. You want findings related to pre-2021 position on Policy 11? Is that what you're trying to get?
I'll elaborate a little bit on that. It would not be sole findings. It would be in addition to the record that's already been compiled. This would be additional record in addition to that for the consideration. But the reason I asked for that is because it was suggested, we all heard during testimony, that the appellant has an idea what those findings would look like, and to provide them ahead of time would give the opponent, the opposition, an opportunity to respond to what those findings might be. And then I've not made up my mind. I would hope that we've all not made up our mind yet on this open discussion that we're having. And so that a suggestion was made that would be a simple way to move forward if the board were to want to look at policy that was that would agree with the application. Now, I'm not saying that we do agree with the application, but this would also give the opponent an opportunity to see what those draft findings would be and to be able to respond to those draft findings.
And I think my question would be, is that in the scope? I mean, this is supposed to be considering what's already on the record that the hearings official heard. So is it allowable to allow findings outside of the hearings official's record? Isn't that?
So it is allowed, but there has to be specific findings made under Lane Code 14080 5C2 in order to allow this additional information. Let's see, what will have to be allowed? If the board is satisfied that testimony or other evidence could not have been presented before the close of the record on the prior hearing proceedings, in determining whether to omit additional testimony or evidence, the board will consider prejudice to the parties, convenience or availability of evidence at the time of the prior proceeding, impact to opposing parties, when notice was given to other parties of the intended attempt to omit the new evidence prior to the close of the record, the competency, relevance, and materiality of the proposed testimony or other evidence, and whether the matter should be remanded, essentially to the hearings official for de novo review.
We have it up here. I'm just looking at it.
Perfect. No, I have to read that.
I'm not sure I'm satisfied it meets that, but.
So what I could do is provide a draft motion once I get further clarification from Commissioner Farr, and then during deliberations, the board can discuss if, rather, that criteria is met to allow proposed findings to be admitted.
So I'm sorry, I was trying to read that.
Oh, it's
So
okay.
you're suggesting make the motion, see if it gets a second, and then in the discussion of the motion, determine whether
Correct.
it meets this criteria.
Correct. But before he makes the motion, I'd like further clarification so I can make sure that I'm providing him the correct motion so that parties know what they're allowed to submit findings on, so that it's clear. So if I may, or do you?
Yeah, and I'm basing this upon what I thought that I'd heard as advice. If we look at option 3, it was moved to direct staff to return with the revised orders, reversing the hearings and providing the findings. This would have the applicant providing the findings as opposed to, and I thought that's what I'd heard you say.
Shauna, can you answer Commissioner Farr?
Yes, it will, I think your motion said parties. in
Interested
restoring-
parties.
Interested
absolutely.
parties.
And some of it may be actually providing the testimony and the suggestion, and some would be responding to the suggestion. Now, I'm kind of winging it a little bit here, and it's based upon the discussion that I thought we'd had, and trying to bring this to a conclusion where we can move forward with something to actually discuss at the next meeting.
So we have two draft motions. This one you're still seeking clarification on, but you have the other one?
Yes. Can I proceed with asking questions, or are you wanting me to give the first motion?
Leave it to
I
Commissioner
would love to be able to clarify it.
Okay, so let me. Let's see. Let's see the draft. So what I'm thinking, it's sounding like how, based off what you're saying for the clarification, you're wanting proposed findings related to policy 11 and its interpretation, based off pre-2021 position that policy 11 does not apply to forest template dwellings. Does that sound like what you're?
I don't know the exact language of what the pre-2021 is, but yes, that is the direction.
Can you confirm for me, Shauna, is
So-
that what option 3 would be?
Would I be correct in saying that the pre-2021 status quo that you're referencing is the position that policy 11 does not apply directly as an approval criteria for forest template dwellings?
Yes.
Okay, that's what I thought. Okay, that's helpful. I'm just taking a moment to refine the motion.
And Shauna, when you speak, if you could either pull the mic closer to you or lean in when you speak, thank you. I'm just getting some notes from folks that are hard to hear. Thank you so much.
Okay.
Apologies.
Let's see. So Commissioner Farr mentioned that he's willing to do 2 separate motions. And so do we want to go back to where we were starting with A related to, okay.
Yes.
And then the board I can read what the motion is, the board can deliberate, the board can make a decision on that, and then I can go into the proposed findings and give you that motion.
The first one may be a simpler discussion. But.
Okay, I'm seeing a head nod from the chair. Okay, so let's make sure I have this good. All right, I have to open it again. Accidentally closed it. Okay. To move to continue the hearing and reopen the record for the limited purpose of admitting additional disclosures from the commissioners and written rebuttal or challenges to the substance of such disclosures. These disclosures may include ex parte contact, personal knowledge, biases, or prejudgment. The commissioner shall submit any additional disclosures in writing by email to Shauna Adams, Senior Planner, at shauna.adams@gov.md. shana.adams@lanecountyor.gov by October 22nd, 2024. The parties shall submit any rebuttal or challenge to such disclosures in writing by email to Shauna Adams, Senior Planner at shana.adams@lanecountyor.gov by November 5th, 2024, at which time the record shall close. The hearing shall be continued to a date and time to be determined in Harris Hall for deliberations for submittal of additional disclosures and written rebuttal challenges. If you want to so move it.
So moved. Thank you, counsel.
Is there a second?
I'll second it.
And so without a second, there's no production of materials to support the challenges?
Correct. It would not be, the board would continue as planned and not,
We have this other motion still to consider, but on this item,
yes, you can't.
The motion dies
That's a
for
good
lack of
point.
second.
Are you asking me if the motion dies?
I'm asking if this motion does not get a second or does not get a majority of the board voting in favor of it, there is no opportunity or requirement for commissioners to present materials to speak to the challenges.
Correct. They still can if they so choose, but that would create procedural issues that we would have to address if they chose to do that without continuing the hearing at this time.
And Chair, my point was to try and wrap up what Mr. Malone was asking for in a way that maybe would satisfy him in terms of the material that we could produce for him. And if there's no second, then I'm fine with that.
So we have another motion dies for lack of a second. Is there another motion?
Okay, yes, there is. I am figuring out how to refine it based off the fact the first one did not. So I have to go back here. Let's see. Is it okay that I take a couple minutes so that we get it correct? I can do this pretty quickly, but, okay. Okay, here we go. Thank you. Move to, for you, to move to continue the hearing and reopen the record for the limited purpose of emitting proposed findings. Let's see. Actually, I'm going to restate it. My apologies. It's a lot of different things. So please ignore that part. Motion to continue the hearing and reopen the record for the limited purpose of emitting limited additional testimony under Lane Code 14080-5C2 in the form of proposed findings related to Policy 11 and its interpretation based on the pre-2021 position that Policy 11 does not apply to forest template dwellings, which findings shall be limited to arguments that are already in the record. The parties shall submit any proposed findings in writing by email to Shauna Adams, Senior Planner, at shauna.adams@lanecountyor.gov by November 5th, 2024, at which time the record shall be closed. And that is the motion that you can move to do. And if you noticed, I indicated it was for for arguments that are already in the record, because that is my understanding is that is what you were wanting, and so that is the motion that I made.
So moved, and I do have an explanation, a little bit more of an explanation if there is a second.
I'll second.
Been moved by Commissioner Farr and seconded by Commissioner Senega. And if you could, counsel, before I open it up for discussion to the motion, just copy paste the motion in a text to me and the Vice Chair and Tanya, so we have that for the record. Thank you.
And to the motion when you're ready, Chair.
Please, Commissioner.
And the reason I have suggested that motion is because Mr. Close has today, in testimony that we all heard, said it's simpler than it seems, and that a simple approach would be to simply, and I'm using the word simple a lot here, go to pre-2021. And he said that 1984 to 2021, but there have been changes between 84 and 21, but the pre-2021 status quo would be a simple approach to it. So to provide those findings would give us an opportunity to discuss whether or not that is the approach this board wants to take, a simpler approach than trying to draft our own language. That being said, it would give the opponents an opportunity to respond to that proposal. It'd be equal. And again, I am still entertaining testimony before I make my decision.
Is there other discussion to the motion? I have a question, not seeing any other of staff. This is probably for Shauna, and because I also want to make sure it fits this, but this notion of providing an opportunity to give findings that show it would be simpler to revert to pre-2021, did not other deliberative bodies have the option to make that determination in the process overall this time?
I don't think that argument was presented. The applicant, before the hearings official, asked for additional time so they could present the proposed interpretation that they had and to create the record they needed to support it for the board to adopt that proposed interpretation. So that's already in the record and in the form that all parties have agreed is consistent with the evidentiary record and arguments that were raised, or at least no parties objected to that in the form it's currently in.
Thank you. So it's in the record that they wanted more time to do that, or that they did present those findings?
It's in the record they wanted for more time for that. They asked for more time, and they did so by revising their initial interpretation in their final argument after everybody had submitted testimony, and they considered the testimony and new evidence in the record, and they presented it in a form for board adoption that reflects the arguments that they had made before the hearings official to the effect of justifying an interpretation that Policy 11 does not apply directly to forced template dwellings, consistent with the position that was taken before the Nimkish and King holding. So that may already be in the record, and it may be simplest to avoid contest to proceed with what the applicant has already provided.
Thank you, and that's exactly where I was going, if simple is the goal. And because otherwise, I'm not sure it meets this, right? Because if it's already in the record and we're supposed to be hearing based on the hearings, what was in the hearings official record, allowing new arguments is outside the scope of that. But if it's already in there, then it's already in there, and we don't need to do this motion to consider it. Is that not accurate?
That's how staff sees it. I haven't heard anything to the contrary. I think the big question
I would recommend for Council Tran Cafe to chime in on this point.
Thank you. Council, are you on the line, and were you able to follow this discussion?
Yeah, thanks. So I am not familiar with the record, but I understand staff saying that the proposed findings that the motion would allow are actually already in the record. Is that right?
Specific to the Policy 11 interpretation proposed, yes.
Okay. Then I do I do think it would be hard to go through these subsection 2 limited additional testimony factors and find that they justify allowing the submission of additional proposed findings that I understand to be to the same effect as what is already in the record.
Thank you. So if this concept wants to be entertained, it's already in the record and it can be entertained, and we're back to the board deliberating on the record. Right? Yeah, thank you. Commissioner Farr, did you?
When I use the word simple on this, the terms, the pages and pages and pages and pages that you read to us today and that we continue to try to consider are not very simple for someone who doesn't do this for a living. You know, I do poverty and homelessness, man, you know. So it's not easy for us to understand, but if Mr. Close says it is simple simply by just going to what the pre-2021 rules were, then I think we should have an opportunity to discuss what the pre-2021 rules were, and is that something that we want to do or not? We may find, based upon staff information, based upon the opponent's information, that it's a laugher that we couldn't do that. But really, it's right now we all admit this is a very confusing issue, and it's been made to be very, very complicated. And I'd like to boil it down to just a couple of simple facts that we have to make a decision on, and then allow for the people who are good at writing this stuff, which I'm not, to write it under the direction of the majority of the board at that point in time. That's what I'm trying to achieve. The other option is option 3. My other option on this is option 3, to have staff come back with the findings.
Thank you for that, Commissioner. It's a great reminder to me that I wanted to ask this question too, because it seems to me there's sort of two things at work here. One is whether this board wants to consider a review of Policy 11 and how it's being interpreted and provide some clarity, greater clarity for staff for interpreting. But what we're trying to do is do that while considering applications that have been ruled on multiple times, and potentially going against a hearings official who in fact is a trained professional who has read all the pages and had all the time that we haven't had. So is there not a way to review Policy 11? It seems like there's a real interest on the part of many members of this board to have an opportunity to have a conversation and understand how Policy 11 is being interpreted and applied broadly, rather than in response to a particular applicant and a party who maybe has an interest in that applicant's file. Seems like we could achieve what is being asked for, not in response to application, right? We're not getting rid of that option. Is that right?
Yes, if I'm understanding you correctly, that would be true. What I can offer is that currently Policy 11 is being interpreted in the way that LUBA has held it must be interpreted. To the extent that's clear, staff and the hearings official are bound to that interpretation.
May I ask a question on that? And there's a little bit of contention, it seems, on whether or not LUBA has absolute on that. Is there ambiguity in LUBA's interpretation?
Yes.
Okay, well, there is ambiguity. Okay, that's.
And in thinking about, the county's interest, which should be our first priority, if we do issue a decision that isn't legally defensible, who pays attorney's fees and all related costs associated with such a situation? Is that on the county?
I'll defer to Council Tran Cafe. LUBA does. I'll let her answer in what circumstances LUBA would allow attorney's fees, or the Court of Appeals and such.
I would actually have to look into that a little further to give a concrete answer. The general rule is that each party pays their own attorney fees. There is an exception at LUBA for certain affordable housing challenges, which would not apply in this case. And then there is usually, and this is the part I would have to confirm, a body can usually order attorney fees be paid by the non-prevailing party if the positions they've taken are, completely unsupported by the evidence or the law. So it's sort of like a bad faith. But I want to caveat that with, I would need a moment to confirm the scope.
Thank you. Well, that satisfies for me. I think I will not be voting in favor of this motion because I believe if the goal of this board for the long term is to get some better clarity about the interpretation of Policy 11 and how we direct staff to apply it to applications, we can achieve that in a way that is less open to challenge from a being responsible, sort of a risk management liability responsible position. This is a series of applications that have been through extensive process and have been heard by many, many people who do have the training and took the time to read the entire record. So I would be very much amenable to an assignment asking for this board to work with staff on getting greater clarity on interpretation of Policy 11 writ large, but would not be in support of the motion of doing so through an attempt to satisfy a particular applicant who has not had things found in their favor.
To the motion. Thanks. And I'm not certain that I've made myself clear as to what my intention is here. My intention is not to say we're going to do this. My intention is to say let's look at the findings that somebody believes that these are the accurate findings that will help us to do it legally. If it's determined that we can't do it legally, we're not going to do something illegal. I'm not going to say yes to something illegal. If staff and council tells me it's not legal, that we can't do it, then we can't do it. But it will be placed, it will be debated and considered, the suggestion that's been made, and it will be determined to be not legal, and we won't move forward with it. That is the intention of my motion, is to precipitate a decision on this that is going to be definitive. Is it legal or isn't it legal?
Commissioner Seneca, did you have a comment?
Well, yeah, and I just wanted to kind of clarify too, Ms. Adams, thank you, by the way. And this is all because the board hasn't weighed in on this topic yet, right? Like, these decisions have been made because of a LUBA decision that didn't have the BCC's input, correct?
The board has not revisited it and chosen to weighed in on the issue formally through a local interpretation since LUBA has made its ruling.
Right. Okay.
Seeing no further discussion, there is a motion, sorry?
Yeah, to the motion.
Oh, Vice Chair?
Yeah, thank you, Chair. As I understand Commissioner Farr's motion, it bears weight to discuss what he's talking about. I'm not sure the motion exactly captures that yet, of what your intention was. But the board has a duty to interpret ambiguous plan language. That's why we're here. So I think anything that helps us interpret the plan Policy 11 language is what we need to head our sails to. I'm not quite sure this motion does that, so I'm waffling on whether to support that, but the board should not leave it to a court or the staff or any other entity but the board to make the Policy 11 plan decisions. So to that end, if we don't simplify the motion, I can't support it either.
I have no way to simplify the motion, so I'm as presented. And what I will say is that if this fails, where are we? We're at 4:30 and we've not come to a decision. How to proceed.
Well, there's a motion on the table and it has been seconded, so we could take a vote on the motion and then find out how to proceed after that, unless the maker of the motion wants to withdraw. Nope, okay. Let's see if there is a motion on the table. Did you send me two? Oh. So there's a motion to continue the hearing and reopen the record for the limited purpose of admitting limited additional testimony, Lane Code cited, in the form of proposed findings related to Policy 11 and its interpretation, based on the pre-2021 position that Policy 11 does not apply to forest template dwellings, which findings shall be limited to arguments that are already in the record. And then it describes how parties will submit those findings. All those in favor signify with an aye.
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 Those opposed with a nay. Nay. Motion carries 3-2.
And Chair, if I may provide a supplemental motion to add on to that, since it passed to, what I heard was that the motion passed. I need to provide the hearing date, and then it can be so moved, because I provided the date that, that parties could submit.
Yep.
But I need to say the date of the hearing. So
Thank you.
let's see.
Well, I think, so it is in the original motion, and I'll make sure Tanya has it for the record, that parties need to submit those findings in writing by email to Ms. Adams by November 5, 2024, close of business that day. Is that right, Shauna? At which time the record shall close. And then I see you have a second proposed motion that the hearing shall then be continued to November 18, 1:30 PM, time certain, in Harris Hall. Is that not what you're
That's the
referring
part
to?
that was not part of the motion.
Right.
I failed to state it, so it would be, it needs to be added to the motion.
Yep.
That the hearing shall be continued to the date.
So this doesn't need to be a second. This needs to be an amendment to a motion that just passed? Or is this a second motion?
It could be a second motion.
Okay,
I
so,
think that's the cleanest way to do it.
great. Then is there someone willing to move that this hearing shall be continued to November 18, 2024 at 1:30 PM in Harris Hall for the limited purpose of admitting limited additional testimony under the cited Lane Code in the form of proposed findings related to Policy 11 and its interpretation, et cetera, basically setting the hearing date?
I'll make that motion.
It's been moved by Commissioner Farr. Is there a second?
Second.
It's been moved by Commissioner Farr and seconded by Commissioner Senega. Is there any discussion to that motion? Seeing none, I'll call for the vote. All those in favor signify with an aye.
Aye.
Opposed, nay. Nay. Motion carries 3-2. Tanya, we'll make sure you get those in writing for the record. So we have extended the record for submittal of findings and then set the hearing to present those findings for November 18th. I'm seeing another message, Tiffany, make a finding as to the criteria.
Nothing new
Oh,
since you've been
Do
talking.
we don't need to cite anything here? I have that in a message.
Well, during deliberations prior to the vote, the board, I provided legal advice that the board should address the criteria. Let me take a moment. Yes, that's what we.
November 18th?
Yeah.
Monday.
It's a Monday.
Oh, is it a Monday? We. I'm looking. This is November.
There's no meeting on the 19th.
Right?
Okay, you're right. Let's see what.
It would have to be the 12th or December 3rd. Those are the only, I'd have to check with Tanya.
November 12th. Yeah, so the motion would need to be for the hearing to be continued to I'm just trying to see if, with the dates, I think I would recommend at this point that the board continue the hearing to a time and date to be determined, because there's a lot that has gone on today, and I need to make sure that there's sufficient time for people to submit information and recommend a appropriate date.
Yep. So we just passed a motion that we can't keep to because of the inaccurate date. So do we just make a motion to amend that last motion to say date to be determined instead of November 18th? Just as a
Correct.
housekeeping motion?
Correct.
Is there someone who would make that motion, please?
I'll make that motion.
Thank you, Commissioner. Is there a second?
Second.
Thank you. It's been moved by Commissioner Farr and seconded by Commissioner Senega to move to address the previous motion and override the November 18th cited date and instead to say date and time to be determined. Is there any discussion to that motion? I'll call for the vote. All those in favor signify with an aye. Aye. Any opposed? Nay. Motion carries 4-1. Thank you. Thank you, staff.
Chair Trigger?
Yes, Commissioner.
I'm going to offer a clarification as to why I've made this motion. It's not to state an opinion as to whether or not to support the application. It's to move us closer to a decision based upon contentions that are being made by the applicant and contentions that are being made by the opposition. It'll give them a chance to further clarify their view as to whether or not the pre-2021 rules can be applied. And I think that's a discussion that we'll have on the date to be determined. And it should be a good discussion, because at the end of that day, we'll know if we can do it or if we cannot do it.
Thank you. That concludes this item. Thank you so much to staff for all your hard work leading up to this and through this whole process today. Thank you very much. I know that was a lot to manage. We appreciate you. We are coming to the end of our day. We do have item 11, which is commissioner business. Are there any announcements from commissioners today? Seeing none, any future board assignment requests? Seeing none, no assignments to review. Is there any other business before we adjourn? Anything from our administrator? No. Nothing? Great. Thank you. Well then, at the sound of my gavel, we will be in recess. We are meeting tomorrow morning at 9 a.m. in the Board of County Commissioners Conference Room. It is a hybrid meeting, and we have items from Public Works. And at the sound of my gavel, we are recessed until 9 a.m. tomorrow.